Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, period, does the FBI find people? And people misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Welcome back. Welcome back. How was your lunch? Was it good? You watched Dr. Joe? Wonderful, Alita. That's awesome. Welcome back to the Court of Public Opinion. I am the Recovery Addict for an afternoon session of the Green Sky trial. The trial you didn't know you wanted to watch, but here we are. We live here now. I will say this. I ran to the bank. During the break because I had enough time, and I've been needing to go to the bank because I got a check. I got a check from Canada, and my bank says we don't know what to do with that. It's like it's got a routing number just like everything else. You just cash it, and yeah. They said no, so I still have a check from Canada drawn on a U.S. bank account in U.S. dollars, and my bank won't take it. So, yay for that. That's exciting. All right. Well, I've got more banks to try. Welcome, first of all, to Tisha S. Tisha, congratulations. You were first in chat after lunch today. You're pretty excited. You're pretty excited because you're like, chat isn't on screen. It's like you want people to know what you did. And Tisha, I know what you did. You were very first person in chat. It was quiet. It was calm. We were enjoying our lunch break. I put the thumbnail up, still planning on enjoying a little bit more lunch break. And you're like, G! You're like, G! In chat right there. There's the G. G! And yeah, then it's from there, it all went downhill. I mean, even Ayden jumped in. I would totally mess up the results on purpose, says Ayden. But Tisha, congratulations. First in chat gets punished with internet ownership. Who, me? I won? What? Yeah. We're not buying that sweet innocence, batting the eyelids thing. No. You are guilty, 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 as the G shows. The G shows right here. G is for guilty. We're going to sentence you to internet ownership. Tisha, if you would like to remember this and learn from your past mistakes, which I highly recommend, you can go and download for the low fee of 50 cents a permanent copy of your record that is preserved in certificate form commemorating this occasion when you are sentenced with internet ownership. She did it on purpose, Stephen. Throw the book at her. We will. She has to take care of this until we go live again. Everything IP related worldwide. And make her work for it, guys. Make her work for it. All right, we are back. We are back to try to put some sort of a bookend on this trial that is wild out of Thurston County, Washington. Adam hangs his certificates on his fridge. This is Ayden. Now it's a free-for-all. Everyone's just like, whatever. There was intent. I agree. There was intent. I plead the fifth. It's a little late now. All right, yes, so this new trial, it is a one-day trial. It should be done today, meaning if the jury can't get this right by the end of the day today, I have serious concerns for the jury. See, Dr. Joe just had a great live with Paul and Yoli. That's wonderful. I had to run to the bank. I was not able to watch that. He did ask me if I could put up the Top Mark stream again for the counter because he uses that on his live, so I was happy to do that for him. That's wonderful. But yeah, anyway, we might find another way to keep that running so it doesn't tie up the computer that it's using right now. How long will the jury be out for? About a minute. And about a minute is what I'm thinking. May we see the thumbnail? Says Jenny. May you see the? Yes, you can see the thumbnail. Let me show you what we have first. Let's bring it in here, so we can see it full screen in all its glory. Okay, we have a lot of thumbnails here. Thurston County trial. Let's see. Let's go right here. Boop. And it's on media player 2. There we go. Here we go. This is our thumbnail. Let me get out of the way so you can see this. This is the Green Sky trial, and it has I see, what does it say up here above the cloud? I see skies a green. I see skies a green is what it says. Like the song. I see skies a blue. Yeah, but a green. A Green Sky trial with a who called the medics question up there. I'm not sure what's up with them. They're coming over. We've got Abel and Cain, or their descendants, fighting here in the middle. Brother against brother over cigarettes and guns and gun safety, or the lack of gun safety. We've got one of the world's most experienced jurors with a badge from every single agency he's ever worked for, including like the Border Patrol, city, sheriff, police. He's worked everywhere. He's one of our jurors, probably the jury foreman. We've got a blind dog. We have, let's see, Alice. Is it Alice? Who's the girlfriend? I think it's Alice. Taking care of the chickens. We've got the camper that the older brother lives in on the front lawn of Mom's house. He's 44, lives with his fiance in the camper on the front lawn, but that's cool. That's cool. We've got a dog teaching the alphabet with F's. F. Oh, it drops the F's. Drops the F bomb multiple times, I think. What is the sentence he's facing? I'm not sure on this one. It's harassment. So I'm thinking 6 months max. Let's see. We have loads and loads of chickens. Cain and Abel, the knife, the blind dog. That's the mom. A little bit of blood on the ground that the blind dog might step in. I don't know why we have the roaches. Why do we have roaches there? I'm curious as to that part. We have the quiet zone because the jury just would not talk. They wouldn't say anything. And then up there in the corner, I'm not sure what we have. It looks like what's behind the juror with all the badges?
Somebody just sent me a video of roaches fighting.
Well, I
don't know who won.
Those are crickets. Okay, crickets. I thought they were roaches. They're crickets. My mistake. You can see why I was confused. All right, so we're going to be coming back to court here maybe in a little while. We might court hop just briefly to see what else is happening in the world of true crime while we wait. Tootie says, what is this case about? Just tuned in. Pretty much just what you see on the screen, Tootie.
And Alan Murdoch stole it.
Those are crickets for the delay in the defense attorney's words. What you see on the screen is pretty much what we've seen in court, or we've heard about in court. So if you have any questions, submit them like the jury does at the appropriate time. The judge will consider them for answering. But that is what we have in this trial. We've got brothers fighting, a knife, little bit of blood. Who called the cops? Nobody knows. And pretty much that's the scenario.
The zombie apocalypse may be upon us.
It's a case about brotherly love. It is. It's a piece of metal and a stick because apparently a gun, if it's unloaded, is not dangerous in the eyes of the older brother. Are they deliberating? No. We're in the defense case, and the defense is about to make A, an opening statement, and B, call their witness, which is the defendant. The younger brother finally gets to take the stand and set the record straight. He's been silent thus far. And I imagine it's going to be good. The female dog next to the alphabet has the F off. Okay, the F off. Yes, we did hear something about a female dog. Steve, thank you very much for that. Needs a cop or two. We're not sure exactly how many. This case is out of Thurston County, Washington. We've seen a couple trials out of here. We actually like visiting this courtroom virtually, of course.
Talking about stuff that is not relevant.
Oh, Vicky, I wish we were catching up. It's in real time. It's painfully slow. You need to put in your new keyboard button thingy, the sounds of cricket. Oh, that keyboard button thing is a video replay system, which we're trying to get sorted out. To get that working properly, I still need this firmware to be upgraded to software that the company has shown off at NAB. They showed it off at the North American Broadcast Show, but they have not released it yet. So I'm waiting anxiously with bated breath for the update for the software. I was watching a trial during lunch, and after jury questions, the accused is allowed to ask questions. Crazy. Wow. Where was that from? The accused you get to question your accuser. It's an interesting take on it. One spectator in court? Yes, just the mom, I think. All right, they're literally slower than the sloths of Zootopia. It's so painful. I think she'll go faster once she's in her own case, because that's what she's prepared for. Cigarettes? Yes, that's the cause of the fight. Cigarettes. The younger brother had some. The older brother wanted them. He gave him one in the morning, but then after the older brother took a nap for 3 hours, woke up again and demanded another cigarette. The younger brother's like, no, this is my last one, and you can't have it. So, are the chickens playing football? They're doing something over there. They're getting up to chicken business. It's like pigeon business, but not as serious. He is waiting for the black magic experts to give RA the newest and bestest spells. Jim Bob, that is an accurate representation of what we're waiting for. Love those folks over at Black Magic Design. They make some cool products. Haven't had a 3-hour nap since I was 8 years old, says Ivan. You're missing out. Apparently, that's what you do before you get in a fight with your brother. All the while preaching from the Bible that Cain and Abel were wicked for getting in a fight with each other. You're not supposed to hurt your brother. So 5 times he spouted, apparently he spouted the truths from the Bible about not hurting your brother, while simultaneously punching him and kicking him while he's down, I might add. How do I know that? Because he testified that he did it out of his own mouth. All right, so yeah, that's where we're at. Tulips and Chimneys. It's a crazy case. It's crazy. Brothers don't hurt brothers. Wham! Take that. Take that. And that. Stay down. Brothers don't hurt brothers. Mm-hmm. Where's the Band-Aid on the thumbnail? It might be on there. We might have to zoom in. Zoom in and see. All while your significant other, fiance, soon to be wife, is taking care of the chickens for 3 hours. The actual charge here in this is harassment, domestic violence. It's a harassment, domestic violence case. And it's in a fake court that's in a rented building that does not look like a court. And it's over Zoom. I mean, I don't know what else you could ask. It's a Zoom court in not a courthouse with pandemic spacing chairs. They show the jury. The judge is fake. He's a commissioner that pretends to be a judge. Okay. Seriously. What else do you want? What else do you want? We have the defense attorney takes literally 1 minute breaks between questions. I mean, like painfully 1 minute. And then when she does ask a question, it's like, it's way so past allowed. It's not allowed. The objection comes out 3 words into the sentence, and they're sustained. That's it. Why am I not on the screen? I was hiding so you could see all the picture. That was it. Let's see. Let's go back here. But I want to see Isaac beat this. I'm rooting for Isaac. I don't know why. It sounds like, obviously, Isaac, eye itches. Isaac has issues, as does his brother. They both probably need a little bit of help. But I want Isaac to win in this one. I'm like cheering for him a little bit. He's got a public defender who's not doing the best defense. He takes a minute break between words. There are very long pauses in here. Why is the not judge allowed to pretend? Because they all agree. True Crime Kitty, it's funny. He says at the very beginning, it's like, do all the parties stipulate that I, as a commissioner, can act as judge and hear this case? And they're like, sure. It's like, is that all it takes? Is that all it takes? It's like, hey, you guys good with me being judge for a day? Yeah? Yeah? All right, let's do this. Give me the robe. Give me the robe. All right. Tumwater Troy, and it's sunny and 66 degrees. It's beautiful outside. And to top this off, like every single one of the jury members that were selected, every single one of them, they say, like, all I do all day, I'm retired, all I do all day is enjoy the outdoors, enjoy the weather, enjoy time with my family. Okay. And they're cooped up inside listening to these boys argue over a cigarette for hours. For hours. This has got to be like the worst possible scenario for these jurors. Like, at least make it something juicy. But no, it's a cigarette dispute, a smoker's dispute. The older brother started it. Yes, we've got the wrong guy on trial. The older brother, he demanded a cigarette from his younger brother. Didn't ask, he demanded it. His younger brother said no. He took the cigarette without permission while verbally and physically assaulting the younger brother, according to the testimony that we've heard. He then continued the assault, even though he was not threatened with the knife, according to his own words. And when the younger brother was down on the ground, he kicked him while he was down, all while preaching truths from the Bible about how you shouldn't hurt your brother. And this little brother needs to knock it off. And, puff, puff through this as he's smoking his little brother's cigarette at the time. It's a humdinger of a case. It really is. And the prosecutor is objecting, this is like the last case that will ever be on his record, and he wants a win. He wants to go out with a win, and he is fighting this. He's by himself. He has to go get his witnesses by himself out in the hall, which take forever because they don't want to be here. This is Thurston, Washington at its best as far as the court system goes. It's wonderful. We love it. So what do you have to look forward to? Just more of the same. We're gonna have a defense.
Scratch all that. Oh, that was terrible. I apologize.
Let me see. Hang on. Grab my comment. 2 comments ago. 3 if you don't count this one. Okay.
There's a lawsuit.
Let's see. Back in my day, my older sister and I were fighting. Mom made us put on an oversized shirt. We'd both fit in. We were forced to work together. I suppose the knives work too.
Taking it easy.
You have to wear the same clothes, and it's the Siamese twin treatment. That's what it is. You can't get along. Well, how about you can't depart? You can't leave each other. You depend on each other. Oh man, that is brutal. Capital punishment seems like a lighter sentence for a child like that. All right, we went over the thumbnail. Thank you very much for our fantastic artists. I believe Stephen and Adam are in there. We've got a few other people. I haven't paid attention to who all is adding stuff. I like that it's kept sort of cartoony in this one. I like the overall feel. The cartoon, we're still actually working on it, so it's changing. What you've seen has probably changed a little bit since we last looked at it. But could she have gotten the dispatch info in under the state of mind for the deputy? State of mind for the deputy is a tough one. Maybe a defendant or the victim would be easier. I don't know. The victim was just not cooperative at all on either side. He did not want to be there. Dad duct taped me and my brother together once. That learned a year lesson, right, Bert Bottoms? Pembroke Glamper says, "I guess I'm a Thurston County virgin." You can't say that again after this trial. This will break you in a little bit. We slammed the doors and told each other we hated each other like normal siblings. All right, I'm going to keep an eye on court to see what's going to happen here. Let's take a quick peek. We're not up yet. I think we're going to be back at 4:30. And jury instruction, it's funny, the judge said, you guys both sent me the exact same jury instructions. So we shouldn't have much to argue over this. But it turns out they did still argue. But Ms. Rowe, who really has not been hitting homers today, if you know what I mean. She's been up to bat quite a bit, but I think I would not say maybe struck out yet, but it's a full count. Let's put it that way. It's a full count as far as the strikes go, and there have been no balls. So it's not really a full count. She's about to strike out, I think, and the poor defendant does not know he has an attorney that really has not done him many favors thus far. Maybe she'll get hit by the pitch. It could happen, Stephen. Could happen. All right. I think the brother was a more effective defense attorney. Oh, the victim in this case, the first witness that the state called or the city calls, because this is, I think, the city of, is it Thurston County that's trying this one, or the city? I don't remember. First witness he calls is the victim, the brother, and he's like, "Nope, I didn't put that in the report. I've never heard of that before." You know, he won't give him anything. I didn't feel threatened. I didn't want to file a report. His case is falling down around his ears. It's out of Compton. Right. She's lucky this case seems to be favorable to Isaac. I think she's going to win. Honestly, the jury's just going to be like, you brought charges for this? And they're going to look at the prosecution and be like, this was you shouldn't have done this. You shouldn't have dragged us out of our jobs or out of our retirement for this. That's not worth it. Mrs. Rowe has sometimes when she does really well and sometimes she does less. I'm going to give her the benefit of the doubt and say maybe on her opening statement, she's really going to have a well put together argument that will, well, all it can do is tell what the jury's about to hear from her client, the defendant, because she only has one witness. So the argument's going to be for closing if she wants to argue that. But she only has 10 minutes for the open. 10 minutes, that's probably going to be more time that she questions the defendant on. It's going to be good. This is Earth's most foolish trial. Why doesn't Travis, the older brother, simply eat the other? Says Mathis. Well, that's one way to handle it, Mathis, but we don't do that usually.
Not a camel.
I don't remember. Actually, I do. I remember pulling a knife on a kid once. And I can say this because it was in a foreign country, and I think the statute of limitations has lapsed. This kid was yelling something at me. I'll tell you, it was in Norwegian, and I had a Norwegian. I guess you'd call it a hunting knife, but it's like the kid version. Because my parents thought that would be the coolest thing if all of us just got knives as kids. And so here I am. I don't know how old I was. I was young, maybe 10, maybe 12. Maybe 10, I think I was 10. And we got knives. We got hunting knives. Sharp little hunting knives. And this other kid in the neighborhood was like, was yelling something in Norwegian, which I didn't know. He could have been saying, "You're the coolest person I know," but it sounded much more like, I don't know, something you might hear in the schoolyard from somebody who doesn't like you very much. That was the tone to it. Now, I didn't like threaten him, like pull the knife and wave it. I just took the knife out and I used it to I thought it was, you were supposed to like cut your fingernail with it to show how sharp it is. That's what I did. Well, my brother ratted me out and I got my knife taken away from me. Because my brother said I pulled a knife on the kid. The kid was like, I don't know, 50 feet away. And I had no desire to attack him. But this is how I began my criminal life. This is my first offense. Anyway, so I guess I've been in this brother's situation somewhat. Want to be my best friend? All right, knife. That's pretty much how it went down, Evie, I'm thinking. He's like, these Americans, they're violent. Let's see. I send you a link to our email to your you sent an email. Okay. I don't know if you'll be able to open the link since I'm from Denmark, but please let me know. I want you to watch the short video on it. I'll see if I can find it. It was a subtle threat. It was veiled at best. It was veiled. All right. So let's take a peek here at Thurston. Where are you at, my man? Let's bring Court back up. Was there a horse between you? No, there wasn't. You know what there was between us? There was I got the knife, and my brother, he got, I'm not sure if it was the same shopping trip, but my brother got it's like a water-filled base. Think of, let's see, what is it? You know, like you have like a boxing, what's it called? The thing you punch in gym, where you've got the bag you punch. that stands on the ground, right? And they fill the bottom with like water, so it's like weighted, or they fill it with sand or something, and you punch that. A heavy bag. Okay, it's a heavy bag, but it doesn't hang from the ceiling. Okay, so imagine the base of that filled with water, and it's probably about a little larger than maybe a Frisbee. But instead of having like a heavy bag or something on top of it, it has like a 50-foot long elastic, okay, a little white elastic, and it's stapled to the end of a tennis ball. So it's like a tennis for one was what it was. He got that. I got a knife. He got like a play your own tennis game, and he was playing that. And my knife was not nearly as fun as what my brother got. It's like a swing ball. Like a tennis whip. I'm not sure about the whip part, but so it has the base. The tennis ball is anchored to the ground through this long, well, it sits there. So you can hit the tennis ball, and it flies out, and the rubber band stretches, and it comes back and bounces, and you're supposed to be able to hit it again. In theory, you hit it, and it just comes back and wails on you, and it just smacks you, and you try to dodge it or jump, and then you chase it down and hit it again. But that's what was between me and the kid me and my knife and then that kid. So maybe he was yelling at my brother. I don't know. All right. What did I just walk into? I'm sorry. It was a confession there for a little bit. I have to find a pic. I don't think there was probably only one made in the world, and my brother found it. Whips and knives at 10. Aria's parents were hardcore, I tell you. A wacky ball thing. Yes, Ella B. That's exactly what it was. It's a wacky ball thing. All right. Are we back yet? Nope. Still waiting, guys. Still waiting. Okay, a paddle ball is close. You know the paddle balls where you have the paddle and the ball, and they're attached to each other? Imagine that instead of the ball being attached to the paddle, the ball is attached to like a weighted base. But then you still have the paddle, in this case, a tennis racket. It sounds like squash. It's a paddle ball. All right. Anyway, that's what my brother got when he went to Norway. Plus, he got a knife too. He did. We both had knives because I think he wanted mine when his broke. I'm gonna call him. Hey, remember that tennis thing you got in Norway when you were 12? I know you're 50 now, but can you remember what it was? Anyway, I'm pretty sure it's swing ball. Okay, I'm going to Google it. I'm going to Google swing ball, Vicky. Okay. Swing ball. Okay. No, that's a cheap knockoff. Oh. No. You're right. Wait. Here it is. It is called a swing ball. Vicky, I take it all back. Swing ball champions. Okay, so it's a variant of this. Ready? Here we go. Okay, this is what we've got. So you've got your nobody text right now, or your phone number is going to show up on my screen. Okay, well, I got do not disturb on. There we go. You've got your paddle, and you've got the base, and you've got the ball on a long string, and you hit the ball. It's like that. This is like a modern version. It has like features that his did not have. This is deluxe. Imagine this, 30 years ago, and how it would probably be built better, but not have all the cool features. I'm sure this has like Bluetooth analysis for each hit and everything built in. But swing ball. Okay, they still do make it then. Anyway. All right. So he got two things. You only got one. Maybe that's why he's not my favorite sibling. Just kidding. My siblings are all pretty cool. Okay, we're back in court. Oh, told you a swing ball, says Rona. Modified tetherball. It's like that. It was perfect timing, too. Buckle up, guys. We're going to start. I think we have to go over the jury instructions first. which should be pretty quick because they both submitted the same packet as a suggestion.
Like this case here, if I was in here, I was at my house and I wanted to watch this. I go watch it from home. Not sure how.
Are trials open to the public to view?
Yes, by constitutional. So if I wasn't, if I wasn't in my position, if I was at home, I could watch this. Yes. Huh.
You're welcome to watch anything we do. All of what we do is on YouTube.
Well, I know when I went in for jury before, they said I could come in, but I didn't know you could do it over Zoom and just watch.
Well, you can't be a defendant and do a trial.
No, Zoom. What I mean is if I wasn't in my position now.
Of course.
An observer.
Huh.
Maybe even in jail they can let you watch.
Right. I have reviewed jury instructions, and the state has presented an alternative, not an alternative, a corrected version of the definition of threat. And Ms. Rowe, you've seen that.
I have, Your Honor, and I do not have any objection to this.
Okay.
The
I'll run
defendant.
through the instructions as I have them currently numbered.
Ooh.
Counsel know exactly which ones I'm giving.
We took a blow, Your Honor.
And as I indicated prior to our break today,
we are askew. Thank you. Thank you, Judge.
The both parties submitted what looked to me to be the same instructions.
We've already been brought up in trial once before. We had, I think Ozzie Gardner got called out, commenting on the live feed and saying, "Hey, I'm watching court right now," and the defendant was like read it and said something about, you know, he thinks that the jury is watching the live stream. It was bizarre. It was really funny. It was really, really hilarious. And that defendant ended up joining us on the channel, became a member on the channel. He won his case, by the way, also with Ms. Rowe. Ms. Rowe thought it was a threat.
Instruction number 1 will be 1.02, the opening instruction. Instruction number 2 is the reasonable doubt instruction.
I think she went to go feed the chickens.
Number 3 is the direct or circumstantial instruction. And what we're going to do is Brenda's going to make 8 copies of these so that we'll give one to counsel, so you don't have to reshuffle the instructions you have. So you'll have them in the same order I'm giving them.
Thank you, Your Honor.
Instruction number 4 is the to convict instruction. And it has the correct date, so I appreciate that. Instruction number 5 is the definition of words or conduct. Instruction number 6 is the definition of family or household member. Instruction number 7 is the definition of threat. Instruction number 8 is the definition of malice. Instruction number 9, definition of bodily injury.
Peter, you haven't
Instruction
missed it
number
yet.
10, the definition of knowledge.
They're just going over the order of jury instructions, and then we're going to have the defense case.
Instruction number 11, the expert witness instruction. Instruction number 12 is the duty of the jurors. Instruction number 13 is the closing instruction, and instruction number 14 is the special verdict form instruction. And it appears to me that the verdict forms are in proper order.
Your Honor, the one instruction that wasn't mentioned was the defendant is not required to testify.
Correct. Oh, I tossed it out because I told you. Thank you very much. I do need to add that.
let me just bring something up. And I heard it, and I might have heard wrong, but in the brother's testimony, it sounded like the fight started when the younger brother was coming out of the bedroom where the wife was. And I'm not trying to read anything into it, but did you guys catch anything that just sounded a little bit off there? Not the wife, the fiance. So the little brother with the big brother's fiance.
That will become...
That was the start of the fight. Did you guys hear that? Or was that just me? I'm not trying to be a creep. My little alarm bell went. Yeah. That's all.
That will become instruction number 12. And then we'll move the prior 12, 13, 14 back one number. Instruction 13 then is the duty of the jurors. Instruction 14 is the closing instruction, and instruction 15 is the special verdict form instruction. And I will also make a record that there was an additional instruction that I believe appeared in both proposed jury instructions, which is the instruction which defines the crime of harassment. I leave that out because it's redundant with the to convict instruction. The same information appears in the to convict instruction, so I don't give the definition of the crime instruction.
Understand, Your Honor.
So, Mr. Thompson, any objection from the state to these proposed instructions?
No, Your Honor.
Thank you. Ms. Rowe, any objection from the defense to these proposed instructions?
No, Your Honor.
Thank you. And counsel are ready to proceed to instructions and then to closing argument?
I am, Your Honor.
Okay. And on your behalf, Mr. Thompson, just in case you don't know, Mr. Holcomb reserved 5 minutes of your 15-minute time for rebuttal.
Thank you, Your Honor.
So I'll let you know when you've reached that 10-minute mark.
Wait. He changed his mind? He's not going to testify? They're going to do jury instruction, but go straight to verdict watch?
Let's see. You'll make 9 copies. 9? Yeah. We'll proceed as soon as the copies are made.
No.
And Ms. Rowe, to save some time, you want to write down your contact information, your client's contact information. That way we can all give it to the court so they can contact us once we have a verdict.
Ms. Rowe, can you put my name down there as well and my number? Just put the burner phone.
What's your phone number again?
It's 360.
867-5309. There we go. I always try to mute phone numbers and addresses as best we can.
What's going to happen is the court is going to bring the jury in. The jury is going to, the court is going to read this entire packet of instructions. The one we're going to get will be numbered right to the jury. That's going to take a little bit. Then the court is going to, then Mr. Thompson is going to get up and give his closing statement. I will get up and give our closing statement. And then Mr. Thompson will have the last opportunity to basically wrap his case up. And then the case goes to the jury.
And then,
while the case is being deliberated, you and I are generally waiting around. If you live close enough, the general old-time rule, so if you live like 5 or 10 minutes to here, you could go home and just wait for a call. But if you live kind of far from here, then you do want to hang out in the area, and the clerk will call both of us when the jury has reached a verdict, and we come back. Everybody gets back, and the jurors brought back in when they give their verdict to the judge. The judge will read the verdict on the record, and if the verdict is guilty, Will we be setting over a sentencing date? Are we going forward with that today?
Why do I get the feel this is the longest conversation the attorney's had with their client to date?
Then no. If his brother's not present, then yes.
At sentencing, the alleged victim always gets to tell the court what they want to see, do or do not do. The jury comes back that you're guilty. There's a brother who can be present. Just to tell the judge what he wants.
So the day that they sentence, then he needs to be.
You would have to be here. So if that happens today, we get a verdict today, and the verdict is guilty. If your brother happens to be back also, then we could go forward with sentencing. See, what's likely going to happen is we'll have one more court date just to do sentence.
So I was going to say because they went under to put animals in my nephew after this. So
okay. And as home far away.
it's about another 23 minutes away.
Okay. So likely they won't be there.
So
okay. We might not have a jury verdict until 5. I'll put this to things. So no big deal logistically. If we have to have one more sentence during the sentence, at that hearing we can be on guilt. So we won't have to come back to the courthouse.
So they can do that over Zoom.
Yeah. All right. And Mr. Thompson over there will let your brother know that he,
Right.
to be present on that case.
Okay, so this is taking forever as they staple. I think that was Ms. Rowe's longest conversation with the defendant to date. She explained the whole process and neglected to mention what might happen if they come back not guilty. She just went straight to the guilty side. So if they come back with a conviction, then we're going to go to sentencing and everything. Why not? Why don't you say, the jury's going to go out there, going to deliberate. They're going to find, like I do, that there's no merit to this case, and we're going to be going home here this afternoon. If, on the odd chance, that this jury is completely, hoodwinked.
Counsel, I show 6 exhibits admitted into evidence. Those are the 6. 5 photos and 1 thumb drive. The thumb drive does not go to the deliberation room during deliberations.
Okay. And if I may ask, Your Honor, why would the audio or the thumb drive not go?
Because it's my opinion that that's replaying essentially testimony. And I think it gives weight to that testimony. The other testimony isn't given the same weight by not being repeated. So I do not allow audio recordings in deliberation.
I understand, and the state does respectfully object. But
we'll note the state's objection to state exhibit number 6 not being available to the jurors in deliberation.
And I would agree otherwise with that those are the 6 exhibits that the court did admit.
Okay. And Ms. Rhodes?
And those are fine. No objection to them.
Daybell's done. The stream was taken down. Raid from Top Mark Media. Thanks to all those who are watching Daybell over at Top Mark.
I will make a record that at the time the thumb drive was being listened to, I did indicate to the jury that they would not have it in the deliberation room and for them to give it the attention that they thought they needed to. Understanding that.
Prosecutor's a bit bummed about that. The only evidence the jury could replay. They have 4 pictures. That's all that's going back to the jury. They have 4 photographs. Let's see. They have a picture of the thumb, a picture of the knife, a picture of the head,
Finally,
a picture of the ear. That's it. They have 4 pictures.
Our alternate juror number 7 in this case sit with the jurors during instruction and closing, and then just not go back with the jurors during deliberation. Any objection from counsel to doing that?
No, Your Honor. I actually believe that is the appropriate procedure.
Thank you.
Let's see, Judge
I feel
Boyd.
dedicated this time.
Judge
I like
Boyce.
to have them see it through.
wants to start ending court at 3 p.m. Mountain Time with no afternoon break in Daybell. He wants his evenings. That's cool. Actually, that works for me. Hope that works for you guys.
Which one is number 7? Do they know?
I remember them on this one. So number 7 is.
Back before I left?
Yes.
Okay.
There's a photo of blood on the floor and defendant's clothes. Okay, so maybe the picture of the nose and the ear is one photo. So here's the story. Let me show you the story. We have a thumbnail. First of all, we have a thumbnail that shows the whole. This is the entire court as it went down. I'll move just briefly. I've just got chickens behind me. Chickens in the motorhome. Okay. It's a green sky trial because the prosecutors asked the jury that if the judge told them the sky was green, would they accept that? And all the jury sat there silently, except for one who raised his hand sheepishly and said, no. And they said, why? And they said, because it's blue. So we're calling this a green sky trial. And we have a brother against brother fight. It started over cigarettes and possibly gun safety protocols. We have a blind dog, blood on the floor, a knife fight, but it wasn't really a knife fight. It was a cigarette fight where the offending brother, the one who stole the cigarette from the younger brother, assaulted the younger brother, took the younger brother's knife, cut himself in the process, and injured his head in the process, then threw the knife down the hall, I think where his girlfriend was, if you think that one through. Well, the girlfriend, I guess, was feeding the chickens, and a 3-hour nap's in there somewhere, and that's about it. All while the older brother is yelling about how brothers should not hurt brothers, because it says in the Bible about Cain and Abel. The younger brother does what any younger brother would do, and he says, I'm telling mom. Well, no, he says, I'm calling the police. He calls the police. The police come out, arrest younger brother, and here we have younger brother in court who had his cigarette stolen, who was beat up, kicked while he was down. His knife was taken from him, and because the knife taker cut themselves on his knife, he's now charged with harassment, domestic violence. There we have it. That's pretty much it. The older brother lives at home, 44 years old, fiance, lives also in the mobile home you see there, or at least the representation we have there, in the front yard of his family home where he's lived since he was 4 years old when they moved in 1984. There it is. We have one professional juror. I guess we should say we have one professional with notable interest in this in law enforcement, and that's the one juror who has served, who has been on police, sheriff, Secret Service, Border Patrol. He's worked the gamut as far as law enforcement goes, and he's on there. That's about it. So the older brother testified in court against the younger brother. Older brother did not want to be there, was probably the best witness defense could ever ask for, even though defense has done a terrible job crossing witnesses. It's been bad. PJ, welcome to the gallery. Thank you very much. Yellow Courthouse, thank you. We don't know who called mom, but mom left with younger brother right after this happened. So when the cops showed up, younger brother and mom were missing. I'm showing a slightly outdated version. I can imagine it.
From his dad.
Oh. The jury's coming.
He'll get treated with lots of ice cream. Yeah, and cold Jello.
Ice cream and cold Jello. Did you hear that?
Those tubes fall out naturally.
I don't know how they do it.
48 now. So.
I'm gonna back up just, well, no, I'm not. I'm not gonna back up. I don't want to elongate this process any longer than I have to. I used to love Jell-O until I heard how it was made. I'm not just talking like mix with hot water. I'm talking about where the Jell-O mix comes from.
Seated. I'm not trying to duck out earlier, are you? Juror number 7? All right. Thank you all for your patience. I suspect Brenda has enlightened you as to what the delay was. we'll just put it on the record. Ms. Rowe, defense have any further testimony?
No, Your Honor, at this time, we will rest.
All right. The defense has rested its case. We knew that when at 1:30. And so since then, we've been working on the jury instructions, which you now have a copy of. So rather than bringing you in just to hear that Ms. Rowe and the defense have rested, send you back, work on jury instructions, just decide to do it all at once. So we are now ready to proceed. As I indicated this morning, these jury instructions are like the jury instructions I gave you at the beginning of the trial. They're in writing, and I am obligated, in order to make a record of this case, to read these instructions to you, even though I suspect all of you can read just fine and you don't need me to read them to you, but the courts of appeal need me to read them for purposes of the record in the case, and I will do so. You're welcome to just sit there and listen as I read, or you can read along with me as I read. You will be able to take those instructions with you back to the deliberation room for your use during deliberations. It is your duty to decide the facts in this case based upon the evidence presented to you during trial. It is also your duty to accept the law from these instructions, regardless of what you personally believe the law is or what you think it ought to be. You must apply the law from these instructions to the facts that you decide have been proved, and in this way, decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during deliberations consists of testimony that you have heard from the witnesses, any stipulations, and there have been none, and the 6 exhibits that have been admitted to trial, have been admitted during trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the clerk and given a number, but they do not go with you to the jury room during deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room, with the exception of the audio file that you listened to, and I indicated that to you at the time. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I've asked you to disregard any evidence, then you must not discuss that evidence during deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that has been admitted that relates to that proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The attorney's remarks, statements, and arguments are intended to help you understand the evidence and to apply the law. It is important, however, for you to remember that the attorney's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in these instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or by the law as stated in these instructions. You You may have heard objections made by counsel during trial. Each party has the right to object to questions asked by another attorney and may in fact have a duty to do so. These objections should not influence you. Do not make any assumption or draw any conclusion based on the objections of counsel. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you are to disregard that entirely. You have nothing whatever to do with any punishment they may be imposed in case of violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the attorneys may properly discuss specific instructions. During deliberations, you must consider the instructions as a whole. As jurors, you are officers of the court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. The defendant has entered a plea of not guilty. That plea puts in issue every element of the crime charged. The state is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to these elements. A defendant is presumed innocent. This presumption continues throughout the entire trial unless during deliberations you find that it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have abiding belief in the truth of the charge, then you are satisfied beyond a reasonable doubt. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. To convict the defendant of the crime of harassment, each of the following four elements of the crime must be proved beyond a reasonable doubt. One, that on or about November 20th, 2023, the defendant knowingly threatened A, to cause bodily injury immediately or in the future to Travis Andrew Thomas, B, maliciously to do any act which was intended to substantially harm Travis Andrew Thomas with respect to his physical health or safety. Two, that the words or conduct of the defendant placed Travis Andrew Thomas in reasonable fear that the threat would be carried out. Three, that the defendant acted without lawful authority. And four, that the threat was made or received in Thurston County, Washington. If you find from the evidence that elements 2, 3, and 4, and any of the alternative elements 1A or 1B have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. To return a verdict of guilty, the jury need not be unanimous as to which of the alternatives, 1A or 1B, has been proved beyond a reasonable doubt, as long as each juror finds that at least one alternative has been proved beyond a reasonable doubt. On the other hand, if, after weighing all the evidence, you have a reasonable doubt as to any of the elements, 1, 2, 3, or 4, then it will be your duty to return a verdict of not guilty. Words or conduct includes, in addition to any other form of communication or conduct, the sending of an electronic communication. Family or household member means adult persons related by blood or marriage. Threat means to communicate directly or indirectly the intent to cause bodily injury in the future to the person threatened, or to any other person, or to do any other act that is intended to harm substantially the person threatened or another with respect to that person's health, safety, business, financial condition, or personal relationships. To be a threat, a statement or act must occur in a context or under such circumstances where a reasonable person in the position of the speaker would foresee that the statement or act would be interpreted as a serious expression of intention to carry out the threat, rather than as something said in jest or idle talk. In addition, the speaker must know of and disregard a substantial risk that the statement or act would be interpreted in that manner. Malice and maliciously mean an evil intent, wish, or design to vex, annoy, or injure another person. Malice may be, but is not required to be, inferred from an act done in willful disregard of the rights of another. Bodily injury, physical injury, and bodily harm means physical pain or injury, illness, or an impairment of physical condition. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of that fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted, but not required, to find that he or she acted with knowledge of that fact. When acting knowingly as to a particular fact is required to establish an element of a crime, the crime is also established if a person acts intentionally as to that fact. A witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept his or her opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given for the opinion and the sources of his or her information, as well as considering the factors already given to you for evaluating the testimony of any other witness. The defendant is not required to testify. You may not use the fact that the defendant has not testified to infer guilt or to prejudice him in any way. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence in these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. When you begin deliberations, you should first select one of you to act as presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 of you are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During deliberations, you may discuss any notes that you have taken during trial if you wish. You've been allowed to take notes to assist in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You'll need to rely on notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during deliberations. If, after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. For this purpose, use one of your notepads. The presiding juror should sign and date the question and give it to the clerk, Brenda. I will confer with the attorneys to determine what response, if any, may be given. You will be given the 5 exhibits admitted into evidence that can go to the jury room, these instructions, and verdict forms for recording your verdict. Some exhibits and visual aids may have been used in court but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in each verdict form the words "not guilty" or the word "guilty" according to the decision you reach. Since this is a criminal case, all 6 of you must agree for your return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror must sign the verdict form and notify us, and Brenda will then escort you into court to declare your verdict. You will also be given a special verdict form for the crime of harassment. If you find the defendant not guilty of this crime, do not use the special verdict form. If you find the defendant guilty of this crime, you will then use the special verdict form and fill in the blank with the answer yes or no, according to the decision you reach. In order to answer the special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, you must fill in the blank with the answer no. If, after full and fair consideration of the evidence, you are not in agreement as to the answer, then do not fill in the blank for that question. Members of the jury, if you would please give your attention to Mr. Thompson for his closing arguments. Mr. Thompson.
These are going to be short, guys. These are going to be short. So buckle up.
At the beginning of the trial, I gave a rough outline of what evidence was expected to be testified from the stand. That 2 brothers got into an argument. It progressed to a physical altercation where a knife was drawn and a threat was made. I also indicated that there might be some dispute or slight differences and variations of what the reason for that argument was, but functionally it wasn't important. And I still submit to you that the nature of the argument or what the argument was about still actually isn't important, insofar as I think it's fair to say, at least I would submit to you, that the argument itself is trivial. What's important is that an argument happened, that Travis Thomas then took a nap, woke up, he asked for a cigarette, another argument happened, and it resulted in Isaac Thomas pulling a knife, Travis having to grab that knife to prevent being injured by it. Now, Travis couldn't remember exactly what his brother said. It happened all so fast, he said. But you heard from April, what she remembered being said was, quote from the Bible regarding Cain and Abel, brother killing brother. And then you heard a recording of her interview about 30 minutes after the incident happened. And what she said she heard when that knife came out from the mouth of Isaac, I'll kill you. He pulled the knife and said, I'll kill you. Now, way back in jury selection, we talked about, brothers and sisters, siblings, your own kids, that sort of thing, in thinking about what tattling, I think, is the example I used, or the way I phrased it then, and how a sibling might be reluctant to fully elaborate on what another sibling did, not wanting to get them in trouble. I think one juror mentioned self-preservation. There was a couple examples laid out there. Now, Travis did indicate that he was concerned about what would happen. We tried to get to him to elaborate, but he never would quite expressly say he was afraid he would get stabbed. And I go with that because I want you guys to look at a couple of things in your jury instructions. One's the direct and circumstantial evidence. We talked a little bit about jury selection. The direct and circumstantial evidence. You can take a combination of the two and form a conclusion. He was so concerned the instant that knife started to come out that he grabbed for the blade before it could even left the holster on his hip, the sheath. He grabbed for the blade of a 6-inch knife. You guys saw the picture, and the picture will go back with you. You can look at that knife a little bit closer. It'll spend a little more time than when you guys just passed it around. It's a rather big knife. It's got what I described as a glass breaker, because I don't know how else to describe that little pointy, what looks like a metal pick on the end.
Spike.
And you can also look at the injuries. Now, you can't see the thumb cut because it is bandaged, but you can look at the bandage. You can see the picture of a spot of blood, and both April and Travis told you about that was bleeding pretty good. And the deputy told you that he was injured and medics tended to it. You can see the small laceration on the nose, and Travis described to you the laceration. So you can take what he said, that he was afraid that Isaac would hurt himself or could hurt him. He didn't really elaborate on the fear, but we know he instantly went for the knife to keep it from being used. And he threw the knife down the hallway as soon as he could get his hands, or get it out of the hands of Isaac. I submit to you, that is a person who was afraid that a threat would be carried out. Now, a threat is both words and conduct. Now, you may not believe that Isaac did in fact say the Cain and Abel quote. You may not believe that he said, "I'll kill you" quote. But given the context of what is an argument, possibly a scuffle between two brothers, and rapidly Isaac reaches for a 6-inch knife, 6-inch fixed blade knife, to pull it out, is a threat in and of itself. You do not draw a weapon like that unless you intend to threaten somebody with it or use it in this situation. You're out hunting, cleaning an animal, sure. You're camping and need to cut a rope, shave down a twig for roasting s'mores, sure. But in an argument or a fight with anyone, let alone a sibling, one of two reasons you're pulling out that knife. I submit to you, it's to threaten the person with or to use it, which to use it in and of itself is also a threat. So we have an argument, nap, argument, The knife is pulled, gets his cuts to his hand, he gets hit in the head. And I would submit to you that it's a fair conclusion that the hit to the head may have even been accidental. The cut on the nose may be even accidental. But it all shows you
he hit himself in the head,
that he intended to try to use that knife. One other thing that he did that shows you that he intended to threaten his brother is as soon as the knife is thrown away and his brother goes to take care of his bleeding hand, what does Isaac do? He flees from the house. He's not there when law enforcement arrives. April didn't know where he went. His brother didn't know where he went. He fled. Submit to you, it shows his consciousness of guilt. And what did he say to law enforcement? Law enforcement did contact him. He corroborated the testimony. I got in a fight with my brother. I pulled out a knife. He got his hand cut. That is the evidence before you. Now, I want you to, all the jury instructions are important, but jury instruction number 4 is the one that the state in every case focuses on probably most heavily, or at least the versions of these. We call this the to convict instruction. That's our shorthand for in every case. It says to convict the defendant, the state must prove the following elements. These are, in this case, every element I have to prove to you for you to return a verdict of guilty. First one, that on or about November 20th, 2023, there's no factual dispute that this happened on that date. 3 witnesses testified that this happened on November 20th, 2023. And the defendant knowingly threatened. I submit to you, the state has proved that he knowingly threatened to cause bodily injury immediately or in the future to Travis Thomas. He pulled the knife. He actually did, in fact, cause injury. And he even said the words, "I'll kill you." Killing somebody is bodily injury. Maliciously to do any attack which intended to substantially harm Travis Thomas with respect to his physical health or safety. Again, I submit to you, threatening to kill somebody while holding a 6-inch knife is a threat to harm somebody substantially, their physical health or safety. That the words or conduct of the defendant placed Travis Thomas in reasonable fear that the threat would be carried out. Now, he did hesitate on the fear. I will concede that point to you, that he did minimize the fear that he felt. But he felt enough fear to immediately go for this knife. He felt enough fear to, as soon as he wrestled it away, throw it down the hall. This all shows his level of fear. We also have the evidence that the fear was reasonable. He actually sustained injuries. The defendant fled after making the threats. All show you that these were reasonable fears to have, that the threat would be carried out. To a degree, the threat was carried out. That the defendant acted without lawful authority. Another way of phrasing lawful authority is authority to do something legally. There's no evidence before you that this was legal in any way. The victim did not want this. He did not invite it. He felt the need to defend himself. And this is where common sense can apply, where you consider what is lawful authority for one person to pull a knife on another.
Mr. Thompson, you've reached your 10-minute mark.
Thank you, Your Honor. Just one more minute.
Sure.
The defendant pulled a knife and threatened his brother to kill him while his brother was not armed with any weapon. The threat was made in Thurston County. All 3 witnesses testified that this happened in Thurston County. Defense is going to come up here and make closing arguments, and I'll come back and do rebuttal, and then I will ask you to find the defendant guilty.
Thank you, Mr. Thompson. Ms. Rowe.
Thank you. Good afternoon, ladies and gentlemen. We've heard testimony this afternoon from 3 separate witnesses. And defense's position, our position on this case, is that it did not happen in the way that the state would like to paint it to have happened. This was a situation between brothers, an older brother and a younger brother. It's very important to keep and consider the context under which the incident happened. While on the streets, a person could interpret a knife being pulled on them by a stranger or by someone that they know or disliked. This is not that type of situation. This is a little brother displaying a weapon to his older brother, who was his bully. Now, let's go back through the testimony of Mr. Travis Thomas, because the case essentially rests on what Mr. Travis believed and felt that day. The case does not rest on whether or not what Miss April testified that she believed she heard is true or not. What we do know from Travis's own testimony is that he never heard the words, "I'm going to kill you," come from his brother. That's a huge point that needs extra consideration, because in order for a person to be placed in reasonable fear of something that is going to happen, he would either need to hear it or see some actions that support that. I want to review Mr. Thomas's testimony. He remembers that day well. He acknowledges that there had been some discussion and maybe some argument regarding gun safety earlier in that day. But he did verify that a gun was present earlier in the day during that incident, before this incident happened. In fact, he testified himself that he went and got his hunting rifle out of his bedroom that Mr. Isaac and Miss April both saw. He indicates that earlier he'd had an argument with his brother about drinking, that he laid down to take a nap, and that after a couple hours he woke up, and he woke up to find that his brother was still seeming irritated at him. When asked why he believed his brother was irritated, he indicated that he believed it was about the gun incident or something.
Objection, fact, not an evidence.
Hey, I'll let the jury look at your notes as to whether that's an accurate summation.
He indicated that his brother Isaac came out of his bedroom, indicating that he was going to go outside and smoke a cigarette. Mr. Travis himself acknowledged that he asked his brother for a cigarette also, and his brother told him to F off.
Facts.
We heard from his girlfriend, April, who said that Travis's response was F off too.
Another fact.
But then immediately after that, Travis lunged towards Isaac and grabbed the cigarette out of his mouth. He didn't grab it out of a pack. He didn't grab it out of his hand. He got close enough to grab a cigarette out of another grown man's mouth after being told, no, he couldn't have a cigarette. I would argue that that is very offensive conduct. He also indicated that basically about the same time he grabs the cigarette out of Isaac's mouth, he sees a knife being displayed. He testified that his immediate reaction was, "Ooh, don't do that, put it down." But when asked specifically, he indicated that Mr. Isaac at no time held the knife with the blade pointed towards him, nor did he point the knife at his brother. In fact, Mr. Travis testified that Travis basically had the knife to his side, and his brother was the one who lunged for the knife. That's very telling. And I believe it's very telling in the situation and in the context of an incident that happens between two brothers. This is an older brother and a younger brother. This is a physically bigger brother than a physically smaller brother. What's most reasonable to infer or conclude from Mr. Travis's testimony was that what likely happened was big brother starts to bully little brother by pulling a cigarette out of his mouth. Little brother displays a weapon, and big brother has absolutely no fear, which is why he lunges for the knife and says, "Up, put that down." Those lunging or grabbing a knife that's being displayed in any manner are not the actions of someone who is in reasonable fear that that knife was going to be used against him. I would argue that it would be reasonable for a person who's had a knife displayed to back up, to put some distance between them. That's not what happened here. Because what happened here was an older brother bullying a younger brother, a knife being displayed, and older brother's actions speak louder than words. And what his actions said was, "Give me that knife. You know you're not doing anything with that knife." That's the dynamic of what the situation that occurred today on this date of this incident. This was a brother who wasn't in reasonable fear. First of all, he had not heard a threat at all. He testified to that himself. Didn't hear his brother allegedly say he would kill him. Didn't even know why. Didn't even know that those words were ever even spoken. He didn't testify that Isaac said anything threatening to him. In fact, he indicated the knife at no time was ever pointed in his direction. The state would like to argue that he felt enough fear to go and try to grab the knife. I would argue that actually he felt enough power as the bigger, older brother to grab the knife because he knew his brother wasn't going to act on anything. I would argue that his actions do not support the state's assertion that he was in reasonable fear that a threat had been made and that threat would be carried out. His actions don't support that theory. When asked, his brother also indicated he never heard his brother make a direct threat at him at all. And we also heard from his testimony that although he received what defense would characterize as minor injuries, you will have the pictures to review. I would ask that you look at the pictures, even of the thumb that's in bandage. There's no blood seeping through the bandage. This was not an incident that created a lot of blood evidence. In fact, the pictures that you're going to be reviewing as part of your deliberations show two tiny spots of blood. The injuries on the brother's nose is one tiny scratch. This is not an incident where a lot of blood was drawn. This is an incident between brothers where older brother said, give me that, get me that knife. You know you're not going to use that knife. And his actions show that that was his understanding of the situation. I'd also like to point to the fact that despite receiving minor injuries, Travis nor his girlfriend, who was present at during that same incident, felt threatened enough to pick up a phone and call 911. That was done by Mr. Isaac. Mr. Isaac was involved in an incident where he had to draw a knife on his brother. When that knife was recovered by his older and bigger brother and thrown down the hallway, there's no testimony that Mr. Isaac ran to get the knife and came back at his brother. The testimony that was given today was that Mr. Isaac, first of all, after he displayed the knife, he was tackled to the ground. We heard Mr. Travis's girlfriend indicate that Travis told her himself that while Isaac was on the ground, he punched him. When Isaac got up, he retrieved his knife. He left the premises. He was picked up by his mother, and he was the party who called 911. He called to report an incident, and even in his reporting, he was giving the truth. He told the dispatch that an incident had occurred between he and his older brother. He told the dispatch that a knife was involved. He told dispatch that his brother had been cut by the knife, and he requested aid for his brother. This is what happened at this time. We are not here with you deliberating over a charge of an unlawful display of a weapon. We are here for you to deliberate whether a knife being displayed between an older brother and a younger brother who are in an altercation created reasonable fear in his older brother that he was either threatening him, threatening his personal safety, or threatening his life. In fact, Travis testified to the exact opposite. He didn't hear a threat. He didn't receive a threat. He simply grabbed the knife and unfortunately was injured by his own actions. Mr. Isaac's actions showed he had nothing to hide. This is the reason why he called 911 himself. He did not flee the scene. He left to report the accident, and that's exactly what he did. You might want to focus on alleged statements that Travis's girlfriend indicated she believed she heard, but that's not the issue. It's not the issue as to what statements were made. The issue is whether the brother, the older brother who was involved in the incident, heard any threats, felt any threat, and was he placed in reasonable fear that his younger brother would carry out some type of physical harm? The answer to all of those questions.
Ms. Rowe, I'm sorry, you have 1 minute.
Thank you. The answer to all of those questions through the testimony of Mr. Travis the older brother himself, was that absolutely not. Didn't hear a threat, didn't feel threatened, and in fact, took the knife that was displayed out of the equation. I don't believe, after you consider all of the evidence that has been presented today, that you will be able to find that Mr. Isaac Thomas harassed his brother by creating reasonable fear in his brother that he would harm him. And unless you can find those facts beyond a reasonable doubt, you do have no choice but to find that Mr. Isaac Thomas is not guilty of harassment. Thank you.
Big finish.
We have 4 minutes left in your
Big
time.
finish.
Thank you.
4 minutes left for the state to wrap up on a rebuttal.
I'm going to talk a little bit faster this time since I have only 4 minutes. So defense wants you to think this is an older brother bullying a little brother. There's no evidence to that. That's not what this is about. It's two adult men who had an altercation, and one of them got cut by the knife drawn by the other. Now, the witness said he didn't remember a threat hearing, and in fact, he did clarify that he made a statement to law enforcement that day, and he did make a statement to law enforcement. He didn't remember making the statement, but he did say he made a statement, and it was that his brother said, "I'm going to get you." Now, he didn't remember everything that was said to him. He just remembered his brother talking and saying words. But we have another witness that told you what was said. Travis told you it all happened so fast, it's kind of a blur. You have to go to that day in question, not necessarily what he's thinking about now. Does he fear his brother now, sitting up on the stand and his brother sitting there? No. But there's not a knife in the middle of a fight. Defense pointed out offensive conduct that Travis may have done. That's nowhere in your jury instructions about offensive conduct. It's because it's not an element. No one has to prove that. Defense argued that it's unreasonable to reach for the knife that somebody's drawing on you, that you should just back up. It's not an obligation. That is also nowhere in your jury instructions, that you must back away from a person who pulls a knife. It's because that's something you have to do. You're allowed to defend yourself. He was doing that. He sees a 6-inch knife coming out from the side of his brother's hip, and he reached for it to stop it from getting pointed at him, stop it from being used on him. And I would actually disagree with defense about the amount of blood. I think that picture only shows one droplet. I think the other red droplet you're going to see, other red thing is just dirt or debris. I think there's only one red droplet in there, but you heard it. That the witness, April, said she cleaned up a lot of the blood, and that was a picture of a single droplet. Nowhere in your jury instruction does it talk about the level of injury. In fact, an injury doesn't even have to occur, but an injury did occur. Defense pointed out a lot of things they want you to consider. I submit to you, almost everything defense asked you to consider is not an element to prove this crime, nor is it anywhere in your jury instructions about it, because they're not relevant to what you consider when deciding if a crime occurred. How a person behaves to a threat is different to everybody. Some people very well may back up, turn around and run. Some people may go to defend themselves. Some situations, a person might draw a similar weapon or another weapon. But that's beside the point. The defendant pulled out a knife to threaten his brother during an argument and scuffle. And we know that threat was valid because more than one person told you what he said. Travis said, Travis told us through law enforcement that Isaac said, "I'm going to get you." April told us the Cain and Abel quote, and you heard her own voice 30 minutes after this happened. What was said? She didn't even remember making that statement. Memories can be fuzzy, especially in heightened emotional states. You may not directly remember something. It may not transfer from short-term to long-term. And it's also irrelevant that the defendant called law enforcement, called 911, called for medics. Again, nowhere in your jury instruction does it say there's only a crime if the victim calls. That's not how it works. I would submit to you that he called in an effort to try to get ahead of the situation. It's the same reason why he fled. If I call and get ahead of the situation, I put out my version of the events to law enforcement, then I control the situation. This is not a bully situation where Travis was bullying his little brother. They're adults. The adults had a verbal argument that progressed to a physical altercation, the end result being that Isaac, the adult sitting right there, pulled a knife in a threatening way, said, "I'm going to kill you," and lost the struggle for the knife.
All right, let's wrap it up.
I ask that you find the defendant guilty. And after you find the defendant guilty, go to your special verdict form and answer yes, that this is a domestic violence relationship, that they are blood and family members. Thank you.
Thank you, Mr. Thompson. All right, folks, with the exception of juror number 7, just stay where you are. 6 of you head back into the deliberation room, and Brenda will bring you the 5 exhibits that you may consider during your deliberations. Have your jury instructions with you. As soon as you have reached a verdict, just let us know, and we'll bring you back here to declare your verdict.
Are they going out right now?
Nothing bad will happen to him.
Give a good eye on him.
In that case, we have to turn on the counter. We've got it going.
Right, maybe see it.
Put it on the screen.
So
our chairs give a sigh of relief.
Yeah.
What is it?
Juror number 7, your name is? Nate. Okay, you're one of the Nates, right?
Yeah.
All right. It's always, I always feel guilty about somebody who's selected to be here and then ultimately doesn't get to participate in the deliberations. We obviously do it because we're going 2 days and we need 6. So if somebody doesn't show up for some reason, then we have an alternate. If you're following the Trump trial, they pick 6 alternates there.
Hey, Pickles,
anyway,
not politics.
So I do appreciate you being here and you taking the time and going through this whole process. So we're here, we're off the record. If you have any questions about what you've seen, any comments?
And Your Honor, I actually would ask that we not go into that just because if for some reason a juror has to leave deliberations, he may be called back.
Oh, that's probably a good point. I will ask this, did you provide Brenda your cell phone number?
She told me to write it down.
Okay. Yeah, so we will notify you of the verdict when it comes in, let you know what it was. You're welcome, in fact, to stay if you don't have anything better to do, but assuming you have other better things to do, then we will notify you.
He's like,
yeah.
He's like, so where did you say the exit was?
Contact information. I'll make sure Brenda has it. There she is.
Tisha, you're going to be very unpopular if that's true. Don't manifest that. Don't put that out there into to the ether. He's gone. He's literally sprinting through the halls.
Thanks, Nick. Have a good evening. And counsel, you let Brenda know contact information.
We left it with her already.
Alrighty. It's not even 3, so hopefully they'll have a verdict
in minutes. Today, Judge. They have 4 pictures to look at, and that is it. 4 pictures in their notes. And if anyone has more than 3 paragraphs of notes, they're doing it wrong. Yeah. Here's how. Let me fill you in a little bit. It's almost as if I close my eyes, I can hear the jurors in the jury deliberation room now. In my mind, what I can hear them saying is, we need to pick a foreman. Who can write the fastest? Who can write the fastest? Who's the quickest at checking boxes? You're it. You're it. Yes, go. That's what they're saying. That's what they're saying. They're like, why? This is not worth the $8.50 that we're getting paid. Okay, so they've killed the live stream for right now. Let me show you. Yes, I was. Don't judge Darryl quite yet. While we were waiting, let me show you what we bought. What we bought while closing arguments were going on. I'm super excited to share this with you. Actually, let's see, camera 7. This is what we. Oh, that was it. Did he like it? That was all. Just kidding. Hey, hang on. I'll put the clock back up. I'll put the clock back up so we know how long it's going to be. And please, if we can have some people keep an eye on the feed from Thurston County Courts, Courtroom 4 specifically is the one we're interested in. That would be great. Case box sources 4 is going to be 7, and cut to super source. That way we still have the timer. This is what we bought. We bought a cloud dock. Why do we need a cloud dock? Well, why do we need cables? I just do, okay? I just do. That's the fact of the matter. Blackmagic Cloud Dock, yes, it's from my favorite company. Share disks over 10G Ethernet for editing and global media sharing. Yes, you can see why that's important. Look how happy these people are who are using cloud docks. They're using the 4 version one. We can't afford that. Don't say anything about Mrs. R.A. She's fine. Designed for film and television, 2 great models. We bought the top one right here, the Cloud Dock 2. It shares up to 2 independent SSDs or U2 disks on your network. Includes 2 10 gig Ethernet ports and HDMI for status monitoring. You're going to love the status monitoring. I'm going to show that off in a minute. Dropbox and Google Drive Sync allow the distribution of files globally, so I can record and be uploading them if I have to share them with somebody else. So it's a compact rack mount design. We're not going to do rack mount for right now. We bought this lower one right down here, so it has a power supply, 2 Ethernet cables, 1 for each drive. Oh. Hey, Jen, how are you doing? I was thinking we didn't want to disturb you with anything. Anyway, it also has a USB connection for a direct connection without tying up the network cables, because we're going to be using the network to live stream, and then we want to record using that. So it's Ethernet via USB, which is really, really cool. And then HDMI monitor output, which gives us an awesome view. Check this out. So yes, it can distribute files globally. It's really cool. It looks like that when you use it. But this is the screen. This is the screen, and it goes like this. It'll have 2 drives, so it'll show how much drive space. The illustration shows with 16 terabytes. I can't afford 16 terabytes of storage. We're going to go with probably 4 terabytes to start with. But it literally shows me how much data is left and what's happening, the read, the writes, the everything. I can monitor everything that's going on as we're recording. And the best part about this is that in addition to doing that, I can, with the 10G speed, I can edit video as it's being recorded. So you don't have to finish the file and then copy it over and start recording. I can literally edit as it's being recorded, which will allow me to do the replay machine. So this is one of the required pieces for the replay machine to work. That is in a nutshell why we got it. And it just looks cool. So, and its big brothers get very, very expensive. Yeah, I'm not going to pay $16,000 for a cloud store for 80 terabytes. Not going to happen. So you're not getting it with 16 terabytes, are you? No, I'm getting it. I'll do, I think I'm going to do a 2 terabyte drive to start, and then maybe a second 2 terabyte drive. And do you have 10G capable and enabled network? Yes, I do. Thank you for asking. And gigabit Ethernet, 2 gigabit Ethernet. So if we have to do a sync with a cloud drive or something like that to Dropbox, it will be very quick. My tax dollars are to work. Excellent addition to the studio. I'm excited. I did not buy it from B&H Photo because B&H Photo love the store. They're great. They're devout. They're devout Jewish individuals. How devout? Well, they closed their store on the Jewish Sabbath, which is Saturday, and they close their store for Passover, which is right now. And so they are closed from Monday through May, through all of May. So I ordered this through Sweetwater, which is one of my other companies that I really love. They're more geared towards music production, but they have the same stuff and it's the same price. Plus they offered a 2-year warranty on this for free. So I was thinking ahead. I become alert and awake when talking about tech stuff. I do. Okay, let's show the timer because we might have results here soon. Okay, here we go. And downstream keyer on. There we go. I'm going to keep checking with Thurston to see if we get an update from the court, which we do not have yet. But we'll keep an eye on it. If you guys want to help me with that, that would be great. Sweetwater is awesome. What I like about them, 2 things. First of all, I placed the order, and immediately my salesperson, James, gave me a call and said, "Hey, Scott, just got your order. Wanted to let you know it's the last one we had in stock. We're boxing it for you right now. It's going to be there on Friday." I'm like, "Hey, thanks, James. Appreciate that." And, of course, they're also going to put a little pack of candy because Sweetwater, they put candy in every box they sell. Literally, it's a little Ziploc baggie with some candies. So I was like, "Thanks, here's some candy." So you not only get your product, but you also get like a jump start on diabetes. So that's just thoughtful. Let's see. Super chat not working. Super chat is not working. Let me see. I wonder why. Did we get demonetized for something? Talking about the knife fight? I'm thinking about it. Well, test just came in. Celio, test was working. It's working here. I'm not showing a demonetization. It says we're still monetized. We're still in the green, hopefully. So I'm not sure why it's not working. I know YouTube's had some trouble. Let me end the poll. Let me end the poll because we have a poll going right now. This is about jury deliberation. And unfortunately, as we're now 10 minutes into it, a few of you have already lost. I appreciate all you testing the Super Chat. If each of you wants to test that remotely, and then we can do like a collective stats on what your results were. You guys are amazing. 1 to 10 minutes, 10% people, 10% of you are wrong, absolutely wrong, because we're now over 10%. We're already 10 minutes, we're already over to 11 minutes. Let's see, we have the 10 to 20 minutes, 38%, 20 to 30 minutes. I realize that's only half an hour. That's 44%. So we're probably about 75% of us think it's going to be between 10 and 30 minutes. And then I'm going to need testimony read back. That is just 5% who think it's going to be like, hey, I'm going to be here for the whole day. Jessica says, my husband orders from Sweetwater. He shows me the sweet notes and the candies. Roro, thank you for testing our super chat function. It works great. Kim, it seems to be working for you as well. That's 2 people who've been able to vouch for it. Still not sure if that's going to be like, can we assume just from those 2 that it's working? Regina Crawford says, test. It's working for you, Regina. Thank you. Red Pen, mine works. You guys are amazing. Thank you very much. We also testing the other functions. Red Pen says, let me test the membership function. Looks like I can gift 5 memberships just fine. And Samantha says, I'll see your 5 and raise you another 5 and gifts 10. So you guys are incredible. Congratulations on all those who received gifted memberships. Thank you, Red Pen and Samantha Terry. Red Pen is one of our mods over on the Top Mark Media channel, by the way, if you didn't know. Doing a great job over there with the Chad Daybell case, which is crazy, is legitimately crazy. Ashley says, I love this chat. Ashley also carrying a heavy load on the Top Mark Media channel. Thank you very much for the work you're doing over there. Ellie Veldman, test. The Euro side is working for Ellie. Thank you, Ellie. See, snazzy electronic donation thingy. It's working for Sinbad. And Cielo, thank you. Oh, we've got a call here coming in. Hang on, who's this?
Call from Indy Cindy.
Indy Cindy, how are you doing?
Well, I'm a little aggravated because my super chat won't go.
Have you tried turning it off and on again? I will say, tell me what you wanted to say, and I can answer your question now. You don't have to super chat it. We'll just see if we can.
I want to know if he is found guilty, does that mean life in prison?
Actually, no, and that is a great question, Indy Cindy. It all stems on whether the jury believes that there was a threat to life. Like if he says, I'm going to kill you. If the jury believes that part, it becomes a different crime as far as severity. If that's not there, it's much lower. So the minimum, we're talking 1 to 5 days in jail on the low end, okay? And the maximum, you're talking 5 years in prison and $10,000 fine. So there's a huge spread here that somewhere can.
Yes.
I don't know if the jury knows where this is at, but here's what we know: we've got a police officer a police officer, border patrol, sheriff's deputy / what else? What did he do? Secret Service and FBI and CIA. I don't know what all he did. He did every single. I think corrections was in there as well. He's there. He's going to understand the law very well because he's probably been in a situation where they've had altercations. But police officers, this is why I wasn't surprised that he was not excluded or kicked off. Police officers also see some stuff, and we see stuff every day, and there's some things that are crimes and some things that technically we could charge a crime, but we just realize, no, that's not. The situation was different. I think this is one of those. It's not a serious situation. I believe the defense on this one. I believe that him reaching for his knife was not going to end in a body on the floor. It just doesn't seem logical to me. He was mad at him for 3 hours while he slept. He could have diced him up and put him in the blender in that time, and he didn't.
Yeah, diced, chopped, and spread him on some bread.
Yeah, fed it to the chickens. The evidence could have been gone, and he didn't. Mm-hmm. And I'm saying that shows to me that really it's just talk. It was just talk. Yeah, he's mostly just mad about the cigarette.
Well, I can understand that. Maybe I vape, but I don't smoke anymore. But, it's just, I don't know why Super Chat's not working for me, but I don't want to log out and come back on because I don't want to miss the verdict.
It's going to happen any minute now, I think.
I agree. Okay. Well, love you, R.A.
Thank you, Indy Cindy. Appreciate it. We'll see you
later.
Bye. I'm not suggesting that is a good thing to do, by the way. I probably, the blender is a bit much. I probably shouldn't have mentioned that. Speaking of getting demonetized, feed him to the chickens society. Chickens will eat anything, just for the record. They will eat practically anything. They're like two-legged pigs that way. All right, Thurston County Courts. Let's see if we have any action from Thurston here. District 3 is live. District 1 is live.
Call from
that.
Hello?
Yeah, I had to try to call in and things again.
Who is this?
This is BAP.
BAP. You did call in again. It's good to hear you again. What's your thoughts on the case here? Are you with me on the it's not as serious as the prosecution wants to make it sound, or are you thinking lock this kid up?
The prosecution really, really, really wants to convict this person, and I don't know why. It's definitely not as serious as they want it to be.
I agree. They seem to be reaching. I mean, we all heard the same testimony, and because it happened so quickly.
He said so many ways that he didn't feel threatened multiple times.
He was trying to get the victim to say he was threatened. He's like, no, I wasn't scared. I was worried he was going to fall on it and hurt himself, but that's it.
Right.
So, yeah.
Like, no, I wasn't scared of any of that.
And now
the part that I keep going back to, because it keeps on making me laugh, is when he was like, I was like, no, brothers don't hurt brothers.
While he was kicking him while he was down.
Right.
Oh, my goodness.
Yeah. But yeah, I absolutely agree with the defense. I don't think that defense lawyer, I think something was probably wrong with her health-wise, because she wasn't really on point.
Yeah, she's been better.
I think a better defense lawyer could have argued that better.
I think, honestly, it seemed like a preparation issue, because she couldn't come up with good questions.
That might be it too. She seemed like she just met him today.
She did better on the closing. At least it wasn't halting. It was you could follow it. It was logical on the close. I thought she did a great job on close. I'd give her a B on that. But the state.
But if she had been prepared, she could have made the same argument that you did, that there were 3 hours between when the initial argument happened and when they had the cigarette incident, that he could have done anything to his brother if he wanted to.
Yeah, I agree. Bap, thank you very much. Great to hear your voice again. Good to have you back on the phone. Have a good one. We'll see
Bye-bye.
you. Bye. Let's see. Snazzy Electronic Donation. Thank you, Sinbad, for that. We have Cielo says Marco. The only correct response is Polo, by the way. I do this at the store sometimes, like Sam's Club. When I lose Mrs. R.A., I'll yell Marco. I'm not against doing that. I mean, everyone knows what it is. It's not like I'm being crazy. Karate Cat Mom, test. I see it's working. Thank you very much. Coffee and Crime gifted 5 memberships. Thank you, Coffee and Crime. SF in Texas says mine doesn't work. It's not doing it. I can see you. John Stupple, 8-track stereo deck fund. It does look like an 8-track, doesn't it? Only it takes 2.5-inch drives, the little tiny ones. Serial ATA drives for those that are curious. So I'm getting a Samsung 2 tera. I don't know what I'm getting. I'm getting other flashy, neat stuff is what I'm getting. Let's see. Samsung 870 Evo 2 terabyte, 2.5-inch SATA 3 internal SSD. That's what I'm getting. Lizzie Dog, don't fall for his test trap, guys. He's going to buy another 8-track player. 8-track players were cool. Just because you push the button that makes that chunk noise when it switched tracks. You guys all have used 8-tracks, right? So nod in agreement. You know what that is. Haley's comment says, hello, is anyone there? Can you hear me now? Teresa, super, gifted a super 5 Recovery Addict memberships. Thank you, Teresa. Red Pen gifted another 5 memberships. You guys are absolutely incredible and amazing. Thank you very much for your support. All right. Lots of love tonight. Lots of love. It's a great group. After sitting through that, that's cool. Let's see. 6 Volt, I see you there. I love your logo, by the way. Is that 3D printed or is that all virtual? It looks 3D printed to me. Is YouTube still on coke? Pretty much. Sadly, I know about 8-tracks. All right, the little boy who cried Marco. As an adult, I will cry Marco. They are SSD drives. Please don't say mechanical, so please don't say 5,400 RPM. No. Minimum would be 72. I wouldn't do a 54, but this is these are internal SSDs. They're the Samsung 870 EVO drive, which gives me, I think, just enough read and write speed to take care of what I need to. Suspected spam call is calling. Hang on one second.
Call from Angela.
It's not spam call after all. Angela, how are you doing?
I was just kidding. This is Megan.
Okay, you sounded like Angela. Megan. I'm like, Angela's calling from a U.S. number.
I was working on that. Gotcha.
You did. You did.
I did. Okay. No, I'm just kidding. I was just calling to say hi.
Hey, how are you
and
doing?
tell the chat that I love them.
That is cool. How did you tell me the truth? Did you sleep through this trial?
I did. I slept through all of it, actually.
Wow, you missed. You have to go back and watch it now. Now that you've confessed, you have to go back and watch all of it at one-time speed.
I probably won't do that. I'm not going to lie, because
you're like, thanks, no.
Yeah, I did try that at the very end, at the closings, and it was like, I'll just take everybody's word for it. Whatever they think is probably right.
Yeah. It's
okay, that was it. That's all I was calling for.
Thank you. I appreciate that, Megan. Good to hear your voice.
Just for that.
Yep. We'll see you. Bye.
Okay.
Funny. She almost sounded like Angela, just briefly. She almost had me fooled, other than the phone number was wrong. All right. Don't torture her. Going to have to ban my husband from here. Every time you buy something, he thinks he needs it. Also, he live streams music on a radio show. GMA, don't ban him. Let's talk. Let's talk. Maybe maybe I can direct him to better items than the ones I'm buying for what he's doing. And everyone will be happier because he'll be happy because everything works beautifully and he won't have to buy anything that's not what he needs. But since I've shown you that one, hang on. Since I've showed you this one, just 1 second. We're still waiting we're on verdict watch, right? Is it still going? Yeah, it is. Since we're still on verdict watch, let me jump back to the equipment and show you why this is important. Box 4 for 7. There we go. Okay. So here we are. Black Magic Design. I just showed you what we bought. It's that thing right there in the middle. The 2 great models. We bought the first one. Let's scroll up to the top and say products. I love this. I love the way they build their website. I really do. Okay, so products. Let's go down here for. I can't even see this. My eyes are too bad. What is it? Capture and playback. I think it's here. Where's the Nope, that's not it. Resolve. Here it is. DaVinci Resolve and production. Here it is. Yeah. This is what we bought that we're waiting on for them to deliver. Okay. It's a keyboard, and it's just a keyboard. You say there's no cables. That's right. There's no cables. It's Bluetooth, and it talks to the computer right here that's down underneath my desk. What is Marco? It's a game you play as a kid. We'd say Marco, and then everyone else would have to yell Polo. Marco has your eyes, has the eyes. The person who yells Marco has their eyes closed, and the people who yell Polo are trying to dodge, not get touched. It's often played in a swimming pool where you're like in waist-deep water, chest-deep water, and you try to reach and touch someone. If you touch them, then they become the person who's it, and everyone else yells Marco Polo. There's no desk space, says Mrs. Ari. Yes, this will be under the desk, but, not the keyboard. This keyboard will work with this device, the Mac that's under there, and that will work with, see over here, see these little drives? These are a version. We have the small part on the side, just the recorder, but my switcher itself is going to record to those drives. It will record all 8 feeds all at once. And then at anytime something happens, let me show you this keyboard. This is really cool. When something really cool happens, let me scroll down here so I can show you a picture. Come on, the keyboard's got to be on here somewhere. Lots of more pictures. A lot of hockey on here. Apparently it works. There's the keyboard. Anytime something happens, I just punch this little in button. A point of interest. Boom. And it will save that point. And I can jump back to it. And at any time I can go back and replay just from that point. Or I could say go back, 2 seconds, 3 seconds, 4 seconds, 5 seconds before that and instantly have it on replay. And I can save it to a highlights reel. So at the end of a trial, say in the afternoon, we can say, and here's the highlights from the day. And we can go back and play. Boom, 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 boom. All the highlights of what happened. And I can do it slow motion, fast or slow. This is the speed over here on the side. It can edit the highlight reel. We can push right up to YouTube for a short if we want to, or push it out on Twitter or Facebook or something else. It can do automatic transitions. It does everything. It literally does everything, and it's super, super, super fast. So that's it. That's why we needed the drive that we just got. We shall never miss a great soundbite again. Yes, this is very much true. It says clipped. What did I say that you clipped? That I'll never need anything else again. Okay. Let's see. Haley's comment. Hello, was anyone there? Can you hear me now? I can. Teresa Super, thank you for the 5 gifted memberships. What is Marco, Rona? I think I caught that one. Bug Dugger says, that looks expensive. Here's some pocket money. Thank you, Bug Dugger. It is expensive, but it's very high quality, and I think it's worth it for what we want to do as a channel, and for what I've envisioned for the channel from before I even started going live. I said this is where I think live streaming can go. I'm excited. Says, hey, it's taking a long time. Hey, it's working. Indy City, it's working. It's working. Not guilty is my vote, she says. Thank you, Indy Cindy. Appreciate that. All right. As far as deliberation goes, we're almost to the half-hour mark where all of us will be wrong, or all but 4%. Taking a quick look at court. Still not back yet. I'm surprised. Honestly, I'm literally surprised. Can't wait to see your face when it comes in. Well, Bug Dugger, the drive's going to come in first, and all I know is that the keyboard is going to be shipping in May. Nobody has it yet. So it's shipping in May. Kiss Me a Cow, I need suggestions on laptop for streaming. Kiss Me a Cow, I'll tell you, I've really been happy with my MacBook Air. You don't need the big 15-inch. I have a little 13-inch, but it handles video very well, and it works very well with StreamYard, which for streaming, it has its quirks and its problems, but it just works, and it's very easy to use with guests. But reach out to me on the burner phone after a live stream, and I'll be happy to talk to you over something else. Angela says, just sent you an email. Please check it. Yeah, I've never checked my email so often in my life. Let's see. Angela. You're saying FaceTime works. Angela, the problem is I need to make sure that my home phone is not posted like it was before. Like when we tried to do Teams, it posted my home phone number, which is not good. I can't do that. I do have the MacBook. I think it's the Air 2, the M2. Just one second. It's not the latest and greatest, but it's a good one. Apple M2, 8 gigabyte is the one I have, and it works really well. It's not the most expensive computer out there, but it works. Oh, my son's hurt. My wife's out there. He's going to be okay. Check the burner. I was just checking the email, and now I'm back on the burner. Let's see. Wow. Let me look at that. Let me look at that, Ashley. Is that okay? Before I make a decision. Thanks for reaching out to me on that. Bug Dugger, thank you for the super chat as well. You choose your preferences for the FaceTime. I'll try. I'll look at that. The problem is if I use FaceTime, either I connect on my phone, which then lets you see my studio and everything around me, or I guess I could leave the camera off. Most of my equipment, most of my hardware, the computers are all, the audio stream and the video stream is already dedicated to an input. So if I bring in a FaceTime on top of that, you would have like sound effects that would be carried over on the FaceTime, or you would have, a news feed that we're watching for a police chase, or some, Chad Daybell's trial come in with your audio as well. Check the thermostat. He's crying because he didn't get a new toy. What we did do when I went to the bank and found out that they refused to accept checks from Canada, because apparently their U.S. dollars that they have in their bank are not as good as our U.S. dollars that we have in our bank. I don't know why. But the little one who just got hurt did get a check for a class action lawsuit for a medical, like an X-ray he had, where they charged way too much for the X-rays. And so there's a class action lawsuit that he was included in, and he got a check back. Well, we're not going to let him have the money. It wasn't his money to begin with, but we are dividing the money amongst the kids. And we're talking, I think it's less than $300. Okay. So it's a chunk of money for kids. But it's not going to change his life significantly one way or another. But we did go to the bank and drew the money out. So I think they each get $40. So he is excited about that. Sent you channel name to burner, says Ashley. Thank you very much. Appreciate that. Save your receipt. It's tax write-off. Every single one, Courtney. My accountant has taught me well. I'm not going to do that again. I'm going to try to get write-offs for all this equipment you guys are buying. So if you're under the desk, will you be controlling the new keyboard? Remember, it says no space. I will. The new keyboard can go right here. I won't need the mouse during that. Or actually, I could have it. I think what I'm going to do is I'm going to buy one of those clamp-on racks that clamps to the side of the table and it lets your laptop sit above the table, like floating in the air. I think I'm going to do that, and then I'll have the space under the laptop for the replay. All right. It's the exchange rate. Now the Canada thing, it's drawn from a U.S. bank account. It's a Canadian company. It's Rumble is a Canadian company, and it's drawn from a U.S. bank account, and still my bank won't cash it. But he's gonna need some racks, said Red Pen. Hang on to that money for your kids. Give it to them while they're on vacation. That's a good idea. They'll just blow it on M&Ms or something that they're going to throw up in the car. They won't even deposit. They won't hold it. They flat out said, we won't take international checks. And I said, well, will you handle international wires? They're like, nope. I'm like, what? My credit union will, but my bank won't. And my bank charges me fees. Send it to your uncle. Probably just have to sign it over for his next fundraiser. It's like, look, I can't cash this. See if you guys can do something with it. I'll contact Rumble, but you don't need to buy anything else. Chris. Let me tell you the way things go. I need to buy other things. Nothing from court yet. We're expanding the channel as trying to get more feeds available, and so I will have a couple more of these recording units, which are tiny. I can package them in a quick FedEx envelope and mail them somewhere, and we'll be able to have people on the ground who are technically working for Top Mark Media, who show up in court and grab live feeds of videos that we then put up on the other stream. So that's how we're going to expand. So we'll have other court cases. We hope to have some court cases that basically nobody else has. But we're working on that. We're getting there. They're onto your money laundering scheme. Oh, man. I'm frustrated. I was frustrated they wouldn't cash the check. It's like I drove all the way there. My credit union is 2,000 miles away, is their closest bank. It's the bank I had before I moved out here. And I kept the account. That's actually where all my business expenses are run through. I work for Top Mark Media. I want a polo shirt with the emblem on the front, says Red Pen, and my name on the back. It says #1 employee. That's a good idea. Top Mark Media shirts. The only challenge with that, Red Pen, is that some court cases, or some courts, when you go and visit, they have strict rules as to markings on shirts. And basically, if you have anything written on it, they'll say, no, you can't come in. You can't wear that. I'm working on the badges. I kid you not. We're working on the badges and having, basically, if we do this, when we send out a packet with a recorder, the goal is that we get the recorder back. That's our goal. We want the hardware back, and we'd like it to still work when it comes back. But we would also include a badge, a press pass badge that says you're working for Top Mark Media. That helps identify you to the court because we filed paperwork under Top Mark Media, and they just need to know who is with what agency. It's pretty straightforward. It's not. There's nobody out there that determines who is or isn't press. The courts sort of make up their own rules, and as long as we can work through that, we'll make it happen. I'll start getting Top Mark Media designed together for a good-looking shirt. Velcro advertising, but the badge is really helpful. It's super helpful to show up at court and be able to have that. It makes you stand out a little bit. It helps with the bailiffs. I kid you not. It helps with the bailiffs when you're in court because reporters or people who are with the media get certain privileges in court that the regular public do not. And some of that involves being able to use a laptop while they're in court. Obviously, it can't make any noise, can't do any recording, things like that. But they can use a laptop. Sometimes they can use their phone to text during a trial. Also can't record, can't take pictures generally. But it lets the bailiffs know who is there as media and who is there as just members of the public. And the idea is that members of the media have read, and you will have to, if you do this with me, you will have to have read the court decorum orders, which is all the rules that apply to media, and I have to agree to that, to say I will obey these rules for the court. Because if you don't, the contempt is the alternative, where the judge can just say, okay, we can kick you out or we can throw you in jail, and it's my choice. So it's something you definitely want to be brushed up on and follow. I tried to use the credit union app, but because Canada checks have the signature thing in the weird place in the middle on the back, it would not accept it. Only employees is allowed a T-shirt. I say only employees are allowed a badge. Does that make sense? Only people that are gathering media for us at court through a pooled media arrangement. Steven says, if you do I want a fishnet shirt, please. It makes it really hard to print the logo on fishnet, but the visual is quite vivid, Steve. So thanks for that. I'll have nightmares. All right. Still nothing from Thurston, Washington. We're past the 30-minute mark. Yep, it's going to be contract. We're working on all that. It's, Mammy, also, honestly, I'm choosing the equipment very carefully because I want to minimize, if there is a problem, minimize the impact to the company. It's not cheap. I mean, one of these, a packet with the cables and everything can easily run $750 on the low end. That's if I include, some of these 256 gig memory cards, high speed memory cards. But it's not cheap, but we're working out. I'm not just going to be sending them to anybody. They're going to be people that we have an established relationship with, that we have a level of trust and understanding, and we'll go there. Music Man, thanks for the enthusiasm. Probably also not a good look in court, but Cielo, I'm also surprised we're not done yet, that we're not back. I'm wondering if maybe the courts forgot to start the live stream. Just don't know. Not seen anything yet. Court 4. Nothing yet. We'll keep an eye on it here. You know what would be fun? International case. Angela, yes, if it's in English. Okay, let me just say, my foreign language skills are minimal. So it has to be something we can understand. And if it's a heavy accent, it becomes difficult for a lot of people to understand it.
Call from.
It's Jessica.
Hello, Jessica. How are you doing today?
Hi, I'm good.
Wonderful.
I'm still a little bit upset about the verdict in the Kelly trial, but I'll get over it.
Or the lack of verdict in that case.
Yeah, exactly. Especially when they were so close. So I have a question.
Yeah.
So if you were to for examples, I had a question for you. Mm-hmm. For your media employees, do you allow tattoos?
Oh, what you want, like a Top Mark Media tattoo?
No.
I would say no. I don't recommend that.
I'm saying, do you allow your employees to have tattoos? Because I have 11, so I kind of not on my face or nothing.
It's not even a consideration. What tattoos you have has nothing to do with it. It's
okay.
Basically
okay.
the primary objective would be your ability to with some training, understand the process of how media works and how the pooled media works and your role in it, and how to interface with the court, and just the ability to learn and follow the directions of the court. And then other than that, it's some simple tech as far as saving files, pushing one button on the machine and then uploading files to the internet. So there's a little bit to it, but it's not rocket science for sure.
Right.
And most people would be like, yeah, you show me once, and that just makes sense. So.
Sure. Well, I was just curious about like the dress code and stuff like that, because it's like I don't know if I can hide my tattoos. But my other point is that this is taking so long because it's a hung jury.
No. You cannot say hung jury again. We've only had 2 so far. There is no way.
Me and Britt Bottoms both came to the same conclusion just to mess with you guys.
Don't do that. This has to be just straight guilty or not guilty. There's no lesser included.
I agree. And why do you always get the cases that make my state look like we're a bunch of like hillbillies that don't do anything correctly, that just drink and like shoot guns?
It's random luck of the draw. Something about Thurston County is in the water, but
that's the truth. I used to be stationed at Fort Lewis, and that's not very far from Olympia. So yeah. I can get behind that. But that was it made me laugh earlier.
My oldest son lived up there for about a year in the Pacific Northwest and loved it. Absolutely loved it. It is beautiful. The scenery is incredible. The coast is just gorgeous. It has so much going for it. It has its share of interesting things as well. It's not the utopia that some people think it is. Okay, I'm just going to put that out there. They've got some challenges, both socially, and economically. That things have changed. I mean, there's a huge boost of employment as tech has had a huge rush up there, and it's really neat. I think it's a neat part of the country. It's well worth visiting for sure, especially if you're driving through and not getting pulled over in Thurston County.
No, that's for sure. You always do the speed limit through that area. That and Yelm, and then also through Everett, because they'll get you, because it goes from 70 to 60 pretty quickly.
And don't cross over the Gore Point. The Gore Point.
No Gore Point.
No Gore Point transactions.
No. That's a pretty serious offense considering. But on a not maybe lighter note, one of the things that our state unfortunately does produce are serial killers. So yeah, there's that.
Well, if you've got to be number one in something, why not choose something that stands out?
We export apples, not killers.
Yes, Red Delicious. You guys have amazing Red Delicious apples.
We have hybrid apples. We're like
Do you do Honey Crisp?
Yeah. We do Honey Crisp, and then we do have a Cosmic Crisp, which is like a hybrid between like Braber's and Honey Crisp. Yeah. We're complicated up here. Anyway, I'm gonna let you go. I just wanted to chime in.
Thanks.
And I won't say hung jury again. Oh, sorry.
Angela's mad at you. Thank you so much.
No, don't be mad. Hi, chat. Okay, bye-bye.
Thanks, Jessica. We'll see you. Bye.
Bye.
No, it's great to hear you guys check in. All right, still waiting on a verdict. Nothing yet. 46 minutes have passed. There's one form to fill out. There's one form. Hung jury. This is not going to be retried if it's hung. The court is so far behind. They have backlogs. They can't even arrest the people who have bench warrants. Mr. Farag is still out and free, and he walked away out of court mid-court during lunch break. I'm here for the apple discussion, says Adam. Let's see. Just had a Cosmic Crisp. Honey Crisp has been my favorite. Growing up, it was Red Delicious. I'd flip it over, count the bumps on the bottom, make sure it was a legitimate Red Delicious apple. And I just loved it. Absolutely loved it. And then when I bit into my first Honey Crisp, I didn't realize apples could be that good. They could have that much flavor. Not a big fan of the ones that are more tart green apples. They're just wrong. People should not eat those. I mean, you should save those for horses and maybe hippos. Yeah. I guess if you put them in a pie, once you cook them and you add all the sugar to them, they're better. I would not feel confident applying to help out with Top Mark, unfortunately. Dog lover, that's all right. Not everyone has to help out. We only need a few people, and it just depends on where in the country you are and what your experience and availability is. And availability, unfortunately, is a big part of it because we would need you in court every day for court. So The goat needs to be called Wilhelm for the Wilhelm scream. Green apples are abomination. Amen, amen. Thank you, Jedi Jen. Sir, I love green apples, says Renee. I cannot do it. They're too tart. They're too tart. I'm sorry, I've offended. No Granny Smiths for RA. Honey Crisp is just so good. Fiji, though, I'm not sure about Fiji. I think one of my family members, they're allergic to just Fiji apples. So we can't buy those ones. Frog Who, says Casey. Mr. Frog was a defendant in a case, I think it was a pro se case, and he's suing everybody. He's suing the judge, he's suing the county, he's suing the court clerk, he's suing the bailiff, he sues everybody in the court case. And he has an incorrect perception of the procedures and what they mean. But he walked away from court halfway through during lunch break and never came back. Hello, Kayla. Please don't tell me you're a Green Apple fan.
No, I'm not. I'm a Red Apple fan.
Good. We can still be friends.
Okay, good.
What's on your mind?
I'm glad. So I'm calling specifically for this reason because I think everyone here would be elated like I am because my friends are not and don't understand why. I got this letter to be selected for jury duty in the matter of 3 months.
Kayla, is it a county?
I'm so excited.
Is it county? Is it
nobody
federal?
understands why. I think it's county. So I live in a few counties south of where Delphi is.
Oh, all right. And it's
in Indiana. Yeah.
And it's during that time period?
Yeah. Yep. So
it could
be any time between July and
You could be
September.
a Delphi trial juror?
I don't think so. I hope not. I know too much about that case.
Oh my goodness.
So I don't think so. I think it's just for Boone because the judge signed it for Boone.
Still, holy cow.
Still.
So close.
I'm excited. That's literally all I needed.
So I'm curious what you're going to tell them when they say stand up and introduce yourself and say what career interests you have and what you do outside of court. What's your 2-minute intro?
My 2-minute intro to what? I'm sorry, my son's iPad's blaring.
Oh, sorry. Just when the judge says stand up and introduce yourself, tell us a little about yourself. What do you say and what don't you say?
I have an undergrad as a study of behavior, and I have a master's in forensics. I mean,
Kayla,
I don't know what else to say.
You're already out. I'm sorry.
Yeah, see?
You're out.
And I'm friends with the prosecutor's wife. I don't know what else I would say. That's the thing.
Oh.
Yep.
Well, okay, I'm not going to tell you what to say, but here's some important advice. You have to tell the truth, right?
Oh, yeah.
You don't have to tell everything about you.
Right. And not all the prosecutors know me, just a handful of them.
Mm-hmm.
So we're good. Yeah.
As long as you don't know the prosecutor and you don't know the judge and the defendant and all that, you might be able to carefully craft your words to introduce, say, hey, this is who I am, lived here this long, I've got family XYZ. Some of my interests are, you don't have to say, and I'm a behavioral analyst. Okay. That might be,
right.
that might be, because that unfortunately is a deal killer.
Yeah.
Yeah. Because if you're like,
if it's the judge that signed it, I do know her.
Yeah.
But my lumbar just scratched. If it is the judge that signed it, then I don't know how that will go. So
people are threatening to send me green apples, Kayla.
Oh, okay, that's fine. I'll give them to somebody. It's okay. Sharing is caring, guys.
Sharing is caring. I don't have any horses around here that are hungry that I know of that would eat green apples, but.
Yeah, no, I live in the suburbs, so I don't either.
Hey, we're back. Caleb, we've got to go.
Oh, good. All
we're
right.
back.
All right, bye.
All right, bye. All right, give me just a second. We have, we were back 3 seconds ago. 3 seconds ago.
My understanding, we've reached a verdict. Let's bring the jury in.
Under an hour. Under an hour. It was 52 minutes of deliberation time.
Yes.
So, you know what we need? You know what we need? Hang on. We're going to pause for just a second. Ladies and gentlemen, we have a verdict. After just 52 minutes and 44 seconds of deliberation, the jury of six in Thurston, Washington has reached a conclusion in the Green Sky trial out of Thurston, Washington. After nearly an hour of compelling testimony and nearly 20 minutes of desperate closings, the jury has said, we've heard enough, we've reached a conclusion, we can tell if this defendant is innocent or guilty, and we have a verdict. We've unanimously reached that, and we're going to provide that to the court now. Wow. I've been looking forward to this all morning, all afternoon anyway. Okay, there's not much lead up here. But here we go. Wow. Jury's walking in right now. Here we go. It's always exciting. It's such a small case.
It's my understanding that we've reached a verdict. Would the presiding juror rise and read the narrative portion of the verdict form?
Is it the cop?
We, the jury, find the defendant, Isaac Jerome Thomas, guilty of the crime harassment, bodily injury as charged.
And the special verdict form.
We, the jury, answer the question submitted by the court as follows. Question: were Isaac Jerome Thomas and Travis Andrew Thomas members of the same family or household? Answer: yes.
All right, thank you very much. If you hand the verdict form to Brenda, please.
That's a felony conviction. That's a felony conviction.
All right, folks, the verdict forms appear to be in proper order. I'm going to ask each of you 2 questions. If you would each answer those questions, please. And juror number 1, do these verdict forms reflect your personal verdicts?
Yes.
And also the verdicts of the jury?
Yes.
And juror number 2, are these your verdicts?
Yes.
As well as verdicts of the jury?
Yes.
Juror number 3, these your verdicts?
Yes.
And those of the jury?
Yes.
And juror number 4, do these reflect your verdicts?
Yes, sir.
As well as the verdicts of the jury as a whole?
Yes.
Okay, juror number 5, are these your verdicts? And the verdicts of the jury? Juror number 6, these your verdicts?
Yes.
And the verdicts of the jury?
Yes.
All right, thank you very much. Verdicts are in proper order. We'll accept the verdicts of the jury and enter a finding of guilty.
Up to 5 years. Up to 5 years and like a $10,000 fine is the maximum.
Folks,
could be much lower.
Your obligation in this trial has now ended with your delivery of the verdict. I want to once again thank you all very much for the time and attention you've given this case. Just express the same thing to juror number 7 before he departed. And just so you know, we have his cell number. We're going to give him a call and let him know what the verdict was.
And he's going to be very disappointed with the rest
anyway, thank you very much for all the attention you've given this case. And if this is your first time on a jury, hopefully it's given you some insight into why it's important that our citizens respond to those juror requests and come in and serve as fact finders and disputed fact trials, much like this one was, because we couldn't operate the judicial system the way we do without that. So on behalf of all of us, thank you very much. It doesn't escape me that it's interesting reading the jury instructions and realizing instructions like this, very, very similar, but not exact because they're different states, will be read in New York City sometime in the next 6 weeks.
Judge.
A group of folks just like you, the very same instructions. So it gives us, a sense of how this process works. So we are going to proceed to sentencing, and here you are welcome to remain if you wish to observe sentencing. You have no obligation to do so if you choose to depart. Brenda can make sure you have your phones and
any other personal belongings she may have stolen from you. And you don't need to keep the numbers on anymore. You're also obviously free from any further obligation during this current jury term. So if you want to remain, you can stay just where you are. This will take a few minutes. If you don't want to remain, you're free to leave. I will say that the counsel frequently like to get input from jurors after their trial. So if you're willing to remain either in here or in the deliberation room, the counsel would meet with you right after the trial. Once again, thank you all very much. And before you go, I'll ask, do any of you have any questions for me? Thank you. If you want to stay where you are, you can. If you want to depart, just head right back through the deliberation room. Mr. Thompson, state's recommendation, please.
And Your Honor, the state's actually requesting to set sentencing over to Tuesday or Wednesday next week, so we may contact the victim, so he may be present if he so chooses. I obviously defer to a calendar that you are on, and I can make myself available for that calendar.
And you can have a seat. Was there a request from Mr. Thomas to be present should the matter go to sentencing?
No, Your Honor. I typically do request any victim case to set over sentencing because I want them to at least have the opportunity to consider it removed from just recently testifying, so the emotions of it are not affecting their call on that question.
Okay. I'm hesitating because I suspect I understand what Ms. Rowe was trying to get to was perhaps a reluctance on the part of Mr. Thomas to have the case go forward. So I don't know that he's going to.
That's fair, Your Honor. And I would agree with that assessment that he did not want this case to go forward. So he made it abundantly clear to the state that he did not want this case to go forward.
All right, let's proceed with sentencing today.
I understand, Your Honor. The state is at this time not asking for any jail time. We are asking for the court to impose the 364 days, but suspend it all. However, that might seem like an unusual request given the facts in this case. I think the court's well aware that the facts of this case actually support this being a felony charge. And our office elected not to prosecute it as a felony charge, and instead prosecute it in district court. We did consider the fact of the nature of the relationship, and the circumstances surrounding the allegation, and my multiple conversations with Travis Thomas. I want to make sure I was clear that which Mr. Thomas I'm talking about. My multiple conversations with Travis Thomas, his big concern is his brother's substance use disorder, or what he perceives to be a substance use disorder. And based off the conversations regarding that, the facts that came out in trial, the state would have likely put this into some sort of diversion program in felony court. And I think that those discussions did have down here as well. But ultimately they were not fruitful. So suspending all the time, but requiring a substance use evaluation and follow-up treatment, which I think there will be some pretty intense treatment based off my conversations with Mr. Thomas. I suspect that such an eval would require treatment. And that is frankly what the state's more interested, given the circumstances in this case, than simply putting Isaac Thomas in jail.
He has buyer's remorse.
The state's big concern was that based off the allegations by by Travis Thomas about the substance use problem, that the events that transpired on November 20th might happen to someone not in the family. Meaning, and I gave a hypothetical to Mr. Thomas that my concern was that if Isaac was to go to a bar and get cut off and get angry and pulling a knife on the bartender, that was my concern, which is one of the reasons why the state did continue to go forward, even after Mr. Thomas indicated he didn't wish this case to go forward. With all of that said, the state is concerned about treatment, substance use disorder. We would like 2 years of monitoring of that treatment, 2 years of monitoring law-abiding behavior. And we would ask that all the jail time be suspended during that 2 years and just require the substance use evaluation and follow-up treatment.
Thank you. Ms. Rowe?
Your Honor, I have discussed what the state's recommendation would be with my client, Mr. Isaac Thomas, and he is not objecting to what the state is recommending.
Thank you. Mr. Thomas, anything you would like to say?
That's your chance.
The only thing I would ask is whether or not I have to return this thing that's on my leg or not.
I assume you're wearing a scram device?
Correct.
Okay. All right. And you're not paying for it, correct? The county's paying for it?
No, the county is.
Okay. All right. And I'll answer that question. Okay.
Oh, yes, we'll get an answer.
And my review of the record was that there was nothing else of a criminal nature on the record. Is that correct, Mr. Thompson?
Correct, Your Honor. And I did neglect to request that the knife be forfeited.
Thank you.
He's like, so about this monitor.
I would also like the court to know that Mr. Isaac Thomas was just recently ordered to put the scram bracelet on. The no contact order between he and his brother has already been lifted. There have been no violations with Mr. Thomas with his wearing his scram bracelet. And earlier during the pendency of this case, Mr. Isaac Thomas did let the court know that he is no longer consuming alcohol, that he is addressing any alcohol issues within his family. And so that was what we had already discussed, which is why the state's recommendation is not surprising to him. But he would like the court to know that he no longer drinks and does not plan on continuing to drink. He is addressing some medical issues, and he has not had any violations with the scram bracelet.
Very good. All right. Thank you.
Knives are not like guns. Anyone can buy one pretty much if you're over the age of 18. Let's see if the judge complies.
Your family's happy about that.
Yeah.
Are you happy about that?
Yeah. One thing I do gotta say though.
Sure.
As far as the state was saying about the bars, I wouldn't go to a damn bar in the first place because they're too expensive.
This is okay. Gonna help. Okay, stop talking. Stop talking. Oh my goodness.
All right. Mr. Thomas, I will suspend all 364 days of jail for the next 2 years. During the next 2 years, you're to have not consume any alcohol, no marijuana. You are not to enter any bar or tavern. You are not to possess any firearm or other dangerous weapon, and no criminal law violations. I will order that the knife that was seized, I'm assuming it was seized, Mr. Thompson?
Yes, I forfeited it over to the sheriff.
All right, it will be forfeited. And
it'll be sold at auction.
I will require that you get a chemical dependency evaluation and comply with treatment. You'll need to show proof to the court by the 23rd of June. I'm giving you 60 days to get yourself enrolled and have them send us compliance reports.
So do you get a thing of, or that you can print out of where to go to and all that?
Ms. Rowe will assist you. You have options here in town.
Okay.
And you can go into Centralia as well. So
that would be closer.
Something that would be easy for you. All right. As for the scram device, what I'm going to tell you is this, is that I'll be willing to take that off once we have proof that you are not just had the evaluation, but you are actively engaged in treatment.
Okay.
So once that happens, then Ms. Rowe can get you scheduled on the calendar to come in and get an order from the court for the release from the scram device.
Okay.
Okay.
Wow. What whiplash? The state went for the jugular, got it, and then immediately asked for the bare minimum as far as the sentence.
You've taken a positive first step by, not waiting for a verdict, but going ahead and, stopping your consumption of alcohol doesn't do you any favors. And as you can tell, gets you into trouble. So I suspect your decision-making will be a lot better when it's water you're drinking,
right?
Not alcohol. You should have it. It hasn't moved, so.
I don't know if there was a plea deal
And
offer.
we're going to get you a copy of the sentence order here in just a moment.
Okay.
And then, were you receiving text reminders of your court dates?
Yes, I have one that comes from the courthouse and one that comes from, the pretrial.
Yeah, but you get the one from the court?
I get both.
Okay, well, you'll continue to get, you won't hear from pretrial any longer since you're not reporting to them. You will continue to get one from the court. For example, reminding you that by the 23rd of June, we need to see that you are actively engaged in treatment. And then you also get one here in the next couple of days telling you how to go online and get a copy of the form that we're about to give you.
Okay. So with the pretrial, do I have to address them to let them know, or does that already go through?
They will know this.
Okay.
You can just call them and let them know, but they'll get a record that this case has been resolved.
A year suspended sentence.
All right.
It's not terrible.
We have concluded the matters in this proceeding. Thank you very much.
Yeah. Thank you, Judge.
You're welcome. Good luck, Mr. Thomas.
Thank you. Thank you all.
Yeah. And any of the jurors want to stay for attorneys?
Q&A?
Any of the jurors want to ask me any questions before you go, now that you've heard the whole case?
What happens with our being called for jury? We go.
You're done. Well, yeah, because you're at risk of being called again, or you have the opportunity to serve again. But no, I don't know how they. It's a random selection of driver's license and voting records.
Yeah,
so
it probably doesn't matter.
Yeah, you're not on the current list, so they use this list for a week or 2 weeks.
The jury thought they were throwing the book at this guy. And he's walking out of the courthouse the same time they are. So we are done with the live stream. Wow. Oh man. It surprised me. I thought the state was, or the county was overcharging this. They ended up going with a misdemeanor charge instead of the felony. I thought that's why they were pushing that allegation that he said that he threatened to kill. Because that threat ups it in the felony category. And they wanted the modifier that it was domestic violence, which also is ups the charge, ups the penalties. And they got everything they asked for. The jury delivered it. And I wonder if the jury feels like, that they were just, played for the fool, when as soon as they deliver what the prosecution has asked for, the prosecutor stands up and says, but I don't want any jail time. He just needs to stop drinking. And maybe if he can do that for a year, we're good. The jury's like, well, wait, what? What about us? What about everything we just said? Does that not matter? I guess it doesn't. 2 surprising results from 2 trials, and it's only Tuesday, says Angie. It is only Tuesday. Please see my previous tag chat, says Evie. I'm looking. As of February 24th, selected UK trials, if you're approved, can be accessed remotely via a Zoom link. Currently, only judges are on camera. Might need to be delayed broadcast, but it's a start. Evie, that is a start. If you're approved, it sounds like they're not just going to allow people to restream, but maybe so. How do I get approved? Send me the form. I would file that. I'd file the forms. I'd wear the wig. What do I have to do to get approved there? There are some UK cases that I would be interested in. Hopefully they show more than the judge, though. If this was a jury, I'd be PO'd to watch the state fold like a card table, says KBF. I will stamp parking passes on the way out the door. We'll validate all the parking. Agenda for tomorrow. Renee, a couple things are happening. Karen Reed's starting, so we might be summing that up in the evening or the afternoon. Don't take that out of context, Ashley. We obviously have Chad Daybell, who's still going to be in court in Idaho. That's going to be happening on the Top Mark Media channel, so that will be going on as well. Let's see, tomorrow is Wednesday. Hump Day. Hump Day Yell. Be here early for that. Don't want to miss that. Go cheap, just buy you a Santa outfit. Wig is required. We'll find out more info and send an email tomorrow. There you go. The wig is required. I told you. I'll wear the wig. Yeah, good stuff. We'll look at the cases. Let me see if I can pull up where we are right now with the cases. It's Google Drive. Let's take a quick look at the thumbnail really quickly before we go. Let's see, what was added? A Band-Aid. Band-Aid was added. That was new. We've got a toaster. Is that a toaster? Over there in front of the truck? A blender. I'm sorry, it's a blender. I got the reference all of a sudden. There's another case in Thurston, May 13th, I believe. Josh, if you can give me the details on that one. Depends what the case is. I love the little ones. I like to mix them up. Sometimes we get a big case that's heavy, and I get a lot of messages from people and say, for whatever reason, this is a case that strikes really close to home, either through something that happened family-wise or growing up or something else. And I feel sad when we're on a case for 4 or 5 weeks where some people who have been here since the get-go say this is just too much for me. I like to be able to jump back into a small trial like this where pretty much all of us can watch and learn and listen and just get a taste of how court operates in a different part of the country. So I love changing it up this way. They're still doing jury selection and motions in the Karen Reed trial. What is the Karen Reed one about? Hazelnut, you're going to have to go watch Brandy Churchwell's podcasts, Conspiracy in Canton. I think you have to watch all 23 episodes because she is not done explaining what it is about in 23 episodes of the podcast, and she's doing a very good job. So need to add a deflated balloon. We're done. I'll use this when I save this one. I will update the thumbnail to be this latest version we have right here. So that's our one-day trial. The mods do rock, Amy. They're amazing. Thank you very much for recognizing them for the hard work they do. That thumbnail needs a mug for the merch shop. Let's see. I'm conflicted. Missing Karen Reed for Chad Daybell. You spelled. I see what you did there. I hope Chad's trial ends sooner rather than later. It's going to be long. Red Pen. The reason why I say Chad's going to be long. Look how long Lori's trial took. That was quite lengthy, and she put on no defense. Chad's side is putting on a defense. So I imagine it's going to be a couple weeks longer than Lori's at minimum. Melanie Little is covering Reed too. She's doing a great job as well. I think she's working with Brandy on that. Cover Koberger, yes. I think we're slated for March of next year. March of 2025 is like a tentative date, Kayla, which I'd like to be there in Boise for that one. Before they were going to do a change of venue, let me tell you what I was going to do. I was going to try to set up a camera. There's a bail bondsman across the street from the courthouse in Latah County. And they have a second-story window that has a view. I figured this out all using Google Earth. They have a second-story window that has a view of the courthouse. And I was going to try to work out a deal where I pay them to be able to set up a camera to live stream, like 24/7, a view of the outside of the courthouse. Because a lot of what happens, in the morning, people arriving, the groups and things like that, you wouldn't be able to see. So I was going to do that, but of course, with a change of venue, that changes my plan entirely of where we're going to try to do that. But I'm looking to do things like that to add a little value and information and backgrounds to cases that we are following so we can get some additional footage of other things that are going on. Treehouse trial, LB, that's coming up. I've got to check and see where it's at. I don't know off the top of my head. Let's see. This is a Karen Reed summary. Dead cop, German shepherds, wine, potential corruption, snow, and a mystery. Throw a blogger in there as well. Karen Reed doesn't start tomorrow. Openings are most likely next week. I think they're still trying to get the 19th juror, right? Morgan Larusic says, had my first court transcribing job this week. Exciting. I'm a pro from watching you. That's really cool, Morgan. Transcribing the court record is I guess you can fill us in. It's expensive. It's expensive to get the transcription of court. It can cost $60,000 for a big trial, and it can take a long time. Treehouse is June 18th or 16th, says Brandy Madrid. 20 jurors they're going for, so they have 19 right now. I saw online a tweet that showed that some of the jurors, because they have so many jurors in the Karen retrial, some of the jurors, their view will be from behind the witness. They will literally see the back of the witness's head. There's a deflated balloon being added to the thumbnail as we speak. Our mods and our creators on this have been absolutely amazing. Done a great job. So, yeah, how would you like to be a juror and not be able to see the face of, as you're trying to judge someone's credibility? You can't even see their face. You just hear their voice and see the back of their head. I think I figured out the trial I watched on lunch where accused asked questions. I believe he's pro se, Judge Robert McBurney. Okay, pro se, that makes more sense because he's his own lawyer. That sort of changes things that way. Hey, Mrs. R.A., what did you bring me? Mild, chunky salsa. Just open it. Okay. This is a muscle test. Here I am live on camera, and it's actually green, by the way. It looks invisible, but it's green. There it is. There it is. I was just faking it. Little Hulk moment. Oh, it smells like salsa in here now. Taco Tuesday today? I think so. I think it is Taco Tuesday. Salsa. Oh, the silicone pads are really good. They're really good. It makes your fingers not turn white and hurt afterwards. I like those. Green salsa, yes. Green apples, no. The salsa, the lid was green, which means it's mild salsa. But the salsa is red. Green apples still. I'm not big on green salsa either. Maybe I'll have to sit down with a psychiatrist and figure out why green is just not my favorite color. Let's see. Richard Chambers says, defense motion, put a motion in to allow Chad to see them. They're citing his right to see people during his trial. Defense put in a motion to get them to allow Chad to see them. To see the jurors? Mrs. R.A. is doing great today. We went to the bank together. Love me some pico de gala. Or Gaia. Is it Gaia or Gala? I don't know. It's pico. Mountain Dew to go with it. Tap the edge of the table and twist. You guys, I've offended a few of you with my like for red over green. He meant the jury. He wants to see the jury. Can you read the Maya stuff? Dog Lover, I think the Maya stuff is just scheduling. There's nothing juicy unless Dr. Joe announced something today that I haven't heard. And I missed that because I was running to the bank. Crafter, I see what you've done here. Pickles, not salsa. Isn't Mountain Dew green? It's sort of transparent. Can we go with that? The bottle's green. It's sort of yellow if you look at it. I used to make fun of my older brother, the same one who got a knife and a tennis ball thing. Got 2 presents in Norway to my 1. I used to make fun of him because he started drinking Mountain Dew. And I would insinuate that it came from, animals relieving themselves in the mountains. But then I tried it. Money is green. Yep, and I have a version to that too, as well, apparently. As soon as I have it, I want to get rid of it. I'm like, yuck, what is this stuff? Mrs. R.A., did you see what we bought today? Yeah. Pico de Gallo. Myra, thank you very much. Thank you for the pronunciation guide. Okay, Mountain Don'ts. Jurors have to pass a Corey test for the Karen Reed case as well. I've got to find out about that. I have not looked into that. Wonderful. Are you as excited as I am, Mrs. R.A., Homeschool Ground Zero, about our new acquisition? There's only one answer here. How's the oven working? It's not, Stephanie. We got a double oven when our kitchen exploded, quite literally, in sparks and everything else, and flooded and burned down. When we rebuilt it, we got a double oven with a small oven on top and a bigger oven down below. The bigger oven will not heat, and I don't know why. I don't know what brand it is, but it was a nice one. It's a gas oven, and it just won't turn on. It says it is, but it doesn't heat up. So, unless we have like a stove repair person here in chat that can walk me through that, I don't know what it is. Stopping is easy. It's the staying stopped that's the hard part. I'm breaking up. Yeah, I figured. All right, let's wrap up for the day. It's been amazing. We have had two times we heard the verdict music today, so it's a great day. Might be the igniter. That's what Mrs. R.A. found when she Googled online. It might be the igniter, so I'll have to look and see if I can buy a new igniter or how to fix that. Wendy, we probably bought the same double oven. Clean the pilot lights. I'll give it a try. I replaced my heating element so you can do it. I'm rebuilding a bathroom. After that, I can pretty much do anything in the home. You guys, thank you very much. It has been a lot of fun. Thanks for watching this trial with me. It was a short one. It was a little bit of a weird ending. Not what we were expecting at all. But it was good. It was good, I think. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again tomorrow morning about 8:30-ish. 8:30-ish, 8:30, 45-ish, I think is what it is. Yes, I'll be safe. 220 volts and gas. What can go wrong? We have 220 volts wired over there for the stove, because I wasn't sure if I wanted to do electric or gas. We ran both, and then at the last minute we chose a gas stove, which I'd never had before. I'm so glad we did. It's so good. Sound effects, please. Sound effects are up. They're up right now. Thank you. Toodles. Rona, toodles to you. There we go. Tisha, you did a good job with the internet. Keep it up all night long, please. That would be great, because I need that order to be delivered and shipped and everything, and I'm sure they use the internet to do that. Big thanks to our amazing mods. You guys be good to each other. We will see you tomorrow. Have a good one. Bye-bye.
The zombie apocalypse may be upon us. This is not Burger King. People do not get to have it their way.
Have them send someone with more experience.
I'm not a cat.
When are we going to break for lunch, Judge?
I object.